Vishwan,
My notes on last occasion, Your Lordship has let us take instruction.
Silver Jubilee we will celebrate.
No, Your Lordship. I
Yes.
only seek.
We are in 26, 25 years.
We have already.
Silver Jubilee of a writ petition, OJC.
My Lordship, I have already contacted the legal heirs of the petitioner. They're coming forward, Your Lordship. I need only 1 week time.
Let us see. Let us hope for the best.
My Lord.
Court order hitla lead guest.
16984. Sub item.
186. Silver Jubilee, the priority 20 Silver Jubilee cases. This is celebrating the Silver Jubilee of High Court. Mr. Jagdish Vishwan for the 16984. So, second matter, I am a lead case order. That has become the lead case now. 16984. Mr. Jagdish Vishwan for the petitioner, Mr. D.N. Leka IGA for opposite parties 1 and 2. The Learned Counsel for the petitioner, Mr. Vishwan, refers to the order. The order dated in older matters. You kindly file your Okalatnama. You Mr. so that
to the legal heirs, we file a new Okalatnama.
Refers to the order dated 15/1/26, 10/2/26, and submits that he is in touch with the legal heirs of the petitioner and may be granted for the 10 days time to obtain instruction and file Wakalatnama. But you see, you have to file again the substitution.
Yes, Your Lordship.
Because you are the petitioner, so you file substitution.
Yes,
they are the respondent. The onus is on you to file it.
My lords.
Unlikely, obtain instruction, take necessary steps for substituting the deceased petitioner as well as filing Wakalatnama. The Learned AG expresses concern regarding the pendency of the matter for the last 25 years. The matter for 20 years and the connected matter for 25 years. The matter shall be listed in the week commencing as Hochi. 24 week commencing 16.
I'm much obliged.
कौन चाहूँचंदी आगे बुझंतु
आगे तांकर
ताकू संगे कथा हुंतु फर्स्ट आस्क देम व्हाट रिलीफ दे वांट obviously service benefits legal heirs can claim, so there can't be any two opinions on that.
I will take instruction. Complete.
Item 2.
Gyaneshwar Satpathy Kanti. He is very active lawyer. Where item 2, petitioner none, Mr. D.N. Lenka IGA for the opposite parties. Any instruction, Mr. Lenka?
No.
Kindly take your seat. The matter was presented before this court on 20/3/2019. Thereafter, the matter has never been listed. So, apparently, the matter has never been moved on behalf of the petitioners. So, the matter shall be listed in the week commencing. The week commencing no. We commencing 2/3/2026, indicating that the matter shall be disposed of without further adjournment.
Item 5.
Registry shall intimate the Learned Counsel for the petitioner regarding the next date of his speech. But सेତେବେଳେ तो मोबाइल नंबर नथिला. ठीक है देखो.
Item 5.
Item 5, may I please?
Yes, please.
Lord, I am for the petitioner.
Mr. Bablu.
Parth Agrawal.
Mr. Parth Agrawal. I'm so sorry. Mr. Parth Agrawal.
Lord, I'm for the
For the-
petitioner husband. The petitioner has filed his transfer seeking transfer of CP number 763 of 2024 from Learned Family Court, Cuttack to Milord.
Nath Agarwal on behalf of Mr. Ramdas Achari for the petitioner. Sir, who filed the petition before the trial court, sir?
Milord, the wife filed a CP proceeding before the court below. Respondent.
Which provision? The petition has been filed?
Under section 10 of Divorce Act, Milord.
Divorce Act.
Yes, Milord.
Then,
Milord, the wife resides in Kandhamal. So, I have annexed.
that cannot be.
Milord, the
As the law evolved like that. So Agarwal develop a habit of always be very scrupulous in your words, in your submissions. We are now being watched world over. Residence of wife at a particular place becomes a issue while filing a petition. If that is the law, then you submit that. If that is not, do some research, then make some argument which is legally tenable. Suppose now I dictate that order. Is submitted to Mr. Agarwal that since the wife stays in Kandahar, he could not have filed a petition in Cuttack.
Milord, I'll just.
Then my order should withstand some have some semblance of what legal value. It doesn't.
Milord, earlier the wife had filed a DV case as against the petitioner in the court below, but the same was dismissed on the ground of
Is that
jurisdiction.
sir? You want transfer to make some submission which will support your contention. Filing a divorce case makes the wife has to file at a particular place. A petition under the Divorce Act can be filed at the choice of the parties.
But the wife never intends to reside in Cuttack. She doesn't. It's just
Sir,
a place.
this course, you must understand these questions cannot be asked by this court or the trial court to the wife. This is not a personal fiefdom.
Milord.
That whatever I like, I will ask. Whatever you like, you will ask. Have you got the book?
Divorce Act, I have.
Yes, kindly look at the provision where it jurisdiction, territorial jurisdiction, 18. ठीक है ଆପଣଙ୍କୁ କେତେ ଶିଖେଇଲେ ହେବେ ଆପଣ Yes, Mr. Agrawal.
Milord. Milord, under section 8, extraordinary jurisdiction of High Court.
No. I'm not asking you. You are raising the issue that wife could not have filed a petition in Cuttack. So, which section of the Divorce Act supports you? Or guides you? Whatever. Guides you or guides the court. This is the problem, Mr. Agarwal. Now both of us are struggling. You raise a point. Obviously, I cannot have an answer because that's not my job. You have to educate me. And when I ask the relevant question, both of us are struggling. You take adjournment.
My lord,
And be precise in your information. Straight away hit the point. What is the territorial jurisdiction where it can be filed? And accordingly make submissions.
my lord, just
Because what you are saying is common logic or common sense.
my lord,
Law is definitely, but every common logic and common sense is not law.
my lord, just for a moment, your lordship may kindly come to Annexer 4, my lord.
How Annexer 4 improves your case?
My lord, Annexer 4, a coordinate bench of this court has quashed this DV proceeding as
No,
against.
you are not getting I am not getting your point, sir. Whenever a coordinate bench takes up a DB proceeding in High Court, the jurisdiction will be Kanama.
On the ground of jurisdiction only, has been disposed of, my lord. The DV proceeding, my lord.
Make your submission. What the coordinate bench has held, the Kotak court doesn't have jurisdiction. Make some submission which makes some, at least I could understand what you are saying. I could not follow. The coordinate bench says that Kandhamal court has jurisdiction.
No, my lord.
Then what you are saying? I could not follow you.
My lord, just for a minute. Please.
No. Let us not spend time in reading something which we want to read.
Right.
That the court time is not meant for that. That what I will read, I read many things, so I will read here. I cannot. I have to concentrate on the job. You have filed a petition, asked me to consider that, seeking transfer from Kotak to Kandhamal. Your first consideration is that she stays in Kandhamal. Then the question is that somebody staying in Kandhamal whether can file in Kotak, which is the territorial section defines territorial jurisdiction. You have no answer. I tried to assist you. Due to paucity of time, I could not. Then you say that she has filed a divorce, what is that? Domestic violence case. Whether filing of domestic violence case has any bearing of filing a suit for seeking decree of divorce or dissolution of marriage, you have no answer. Now the third contention you are saying, Annexer 4, coordinate bench has said something. Now I am asking you what the coordinate bench has said, you have no answer.
My lord, I'll analyze.
The learned counsel for the petitioner, the learned counsel, after arguing for some time, has adjournment to address regarding the territorial jurisdiction, where the proceeding under, what is the proceeding under which section?
Under section 10 of the
Under section 10 of the Divorce Act 1869 can be initiated, as it is contended that the wife petitioner before the learned court could not have moved the petition before the learned judge family court Kotak. Learned judge family court Kotak. Yes. Whenever you are seeking a transfer, now I have dictated the order, the choice of the other side is never a ground. You must understand. It's a very, wrong notion to argue that. Why the party chooses a particular forum if the forum is having jurisdiction? You can always say that you do not have jurisdiction. But choice you cannot question. That is absolute freedom of the party. Yes, next please. Agarwal?
Whenever you launch. Next week.
Whenever is not there, sir.
Next week.
Next week starts on 2nd. List in the week commencing 9th March 2026. Or 5th March further. 2nd is a holiday. 5th March. 5-6-7 working hours.
Item 6.
My lord,
Josna Rani Ratta for the petitioner.
this is the first contempt, my lord.
Yes.
The opinion number 2, who is the contemptor in this case, has not implemented the order of the Hon'Ble court. Thus, the petitioner has filed this contempt petition.
Mr. Lenka, are you been served with copy? Doctor instruction.
I'll take it. First time.
The petitioner in the Josna Rani Ratta for the petitioner. Dear Lenka, AGA for the opposite party. The petitioner by filing the petition alleges non-compliance of the order dictated as passed in WPC number order dated 39/2024, passed in WPC number 22734 of 2024. केबे communicate केबे कले due contempt सबले आगे कहबे केबे communicate हला.
Yes,
What is the
madam.
evidence of communication?
Annexure C/2, page number 20 is the receipt. Postal receipt.
We further submitted that this court's order was duly communicated by
25 April 2025.
by registered letter dated 25/4/2025, of which the receipt has been annexed, marked as annexure C/2. Next. The Lord AGA submits that he may be granted accommodation to obtain instruction regarding compliance of the order. How much time, Mr. Lenka? According to the matter shall be listed in the week commencing 30 March, not 30 March. 30 March 2026. If it is kept pending, please take care that it is closed. I don't know what has happened.
No, direction was to consider the.
Exactly. So that is how I was asking you that if it is kept pending without considering, then please comply. Yes,
Okay.
next.
Please, my lord.
Yes, please.
My lord, here, the petitioner is also a teacher, also facing the one criminal proceeding pursuant to the allegation made by one conducting advocate. And the proceeding is still continuing since 2019 till today. Because what happened, my prayer is to transfer the case from the Umar court to that is Dharmagad. Because the distance between the Umargad, from the native place of the petitioner to
Cause of alleged occurrence took place where?
took place at Umar court.
Then how it is distance is my real.
108
This is not matrimonial case.
No, it is 100.
Initially, when you started arguing, I thought it's a matrimonial case.
No, this is not matrimonial case. There's a criminal case. Criminal case 140 kilometers away from his nativity.
So,
And sir,
committing a crime at a distant place does not cannot. Sir, then I have to pass that laughable order.
sir,
That since the crime is committed at a distant place.
the crime is, that is not the crime like this because they are making some allegation of forgery. Suppose,
Sir.
sir, just because
What you do, sir, you decide the time you will argue, then I'll listen to me because otherwise it will not register in you. You have the style of not listening.
No.
So you decide your time. I'll ask this very
efficient to dispose of the matter within a minute.
Yeah.
Now, within a minute, you have to decide.
Our experience the fastest.
Only thing, sir, 140 kilometers away, that is the tribe.
Crime should be sir.
Again?
Sir, ବର୍ତ୍ତମାନ international level le crime ହେଲାଣି.
That is there.
So extradition କାହିଁ ହଉଛି ତାହେଲେ?
No,
You must understand why there is so many.
This honorable court also targeted the matter to be disposed of within a stipulated time. That is there. So,
So that is a bar on me to transfer it.
otherwise it may, sir,
Take your tray.
yes, that is there.
One side direct.
Agya.
Then another court will say that you transfer it. You must understand what is happening.
No, suppose
Directly in conflict of
we
interest.
have to decide if there is any difficulties faced by the petitioner or the accused,
You
then
should
it is
have-
required. If it is required to transfer, then it should be interviewed. Otherwise not. Because since 2019 matter is also pending, now it is 2026.
Problem-
No progress. No progress.
Could be.
Yes.
Mr. Panda, the difficulty is that 2017, 15, 2010, today we are celebrating silver jubilee of a writ petition. We celebrated in the morning. Last time. 2012.
Sir, that
So once I start writing since 2019 it is pending,
yes.
I have to say that it is pending.
No, the matter is also sir, I am the worst victim because what I am the victim because the delay of that proceeding, I could not get my employment. That is that.
The delay in disposal pendency is across the board. Suppose it is a selective case of delay. X, Y, Z. Z case is pending.
Sir,
I cannot.
my lord also dealt with many service matters. I am not required to tender any sorts of advice in that is the ignorant on my part. So only because the delay of this proceeding, an innocent person will not get the employment. That is difficulty.
Sir, you should have filed that writ petition. You are right. But by transferring, how do I
Only one prayer. Let it be transferred, targeted the matter to dispose of 2 months.
understand?
Sir,
You are arguing against yourself. This is a GR case of which year?
2019, sir?
By transferring it becomes 26.
Yes, 26, yes.
So 26 cannot be go ahead of 19.
sir.
ଆପଣ ଏବେ କୋଉଠି ଚାହୁଁଛନ୍ତି ବର୍ତ୍ତମାନ ଡାବୁଗା ଯିବ
ଆଜ୍ଞା ଧର୍ମଗଡ଼
ଉମରକୋଟରୁ ଧର୍ମଗଡ଼ ଯିବ।
ତା ନିଜର
ଧର୍ମଗଡ଼ରେ 24 ମସିହା କେସ୍ ଆଗ ହବ 24 ମସିହା କେସ୍ ହବନି।
no initially case has been registered in that 2019
ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି
ମୁଁ ବୁଝିପାରିଲି sir
ଟ୍ରାନ୍ସଫର ହେଲେ
ଟ୍ରାନ୍ସଫର ରିନମ୍ବର
ଆପଣ ଏତେ ଭଲରେବୁଲ କରୁଛନ୍ତି ଯେ ଆପଣ ବାହାରେ ଯାଇକି ହସିବେ ଯେ he doesn't understand his directing
No, no,
2019 he has case
ନା କେହି ସେମିତି କିଛି କହିବେ ନା
case in the it happens unwittingly what I'll be doing I'll converting a 2019 to 26 case interestingly
No.
19 case has been targeted by the High Court.
that is the coastal belt area is different this is the hilly area Umarkot Kalahandi these are hilly area a person is very difficult on part of a person to cover 140 kilometers that is non availability of communication
Sir, that jurisprudence has not evolved. Only evolution is that suppose the kind of what you call this financial frauds and crimes, they are clubbing up the matters at one place, multiple FIR.
sir
But after a allegation is made, FIR investigation is
Charge sheet has already been filed, sir.
has been filed.
yes
The difficulty, distance of the person, the accused
the person is required to appear before the court
has to.
some reason they might stand urgent
Sir, how can I?
you can sir my lord have better understanding than me my lord have better understanding than me because I will
Try to understand.
sir now it is 2026 to up to today there is no development I am sure because the delay procedure of the criminal
You must
procedure
understand there is already order by this court. As if I have passed the order, I have targeted the matter.
sir
So the court has to be moved.
yes
You have to find out whether in that case any letters have been issued.
Yeah.
What usually happens when we target a matter in High Court, letter comes.
then thereafter he has also filed a petition no these are the difficulties so it may be extended to some
Right.
to be extended that is
That's in administrative side.
sir
That is in administrative side.
Yes.
But in pending cases, it is tagged to the file and taken up judicially.
yes
Because I pass a order judicially.
yes
I may be taking up matters in administrative side and directing that you dispose of these
Sir,
matters.
sir.
How many cases are pending? So your submission and concern is absolutely correct.
Sir.
But the answer is very difficult what you are saying.
Yes.
That I have transformed, make it a 26 case. Already there is a direction by the High Court to target it. So that I cannot override.
no sir 2019 to 2026 but despite the target the honorable high court targeted the matter has not yet been disposed
That
of
is only in December. Only in December.
only December 2 months has already been elapsed. One charge sheet has been filed. That is only the case of that is
Sir, that is directly in conflict with Supreme Court decision.
sir.
Directly in conflict. That targeting matters is direct conflict with Supreme Court decision. That's
Sir.
the problem. Para 43 of Constitution Bench.
Sir.
Asian surfacing.
Yes.
And then I'll show you can read those judgments right now. So I cannot do that also. I have stopped doing. The problem is that there are. Our concern. I pass an order for targeting because my concern is that a person is like.
Now, why there is a targeting? Because there is a delay.
After you complete, I'll start so that you will not interrupt me.
No, sorry.
Today I was listening to one of the judges giving a speech in
Supreme
Court competition.
Yes.
So C.K. Daftari, the great Chandubhai Daftari was arguing. The petitioner, by filing the application, seeks transfer of the GR number 504 of 2019 corresponding to Dabuga PS case number. Pending before the learned JMFC Umar Court to the learned JMFC Dharmagad under section 407 of CRPC.
Okay.
Purna case of
Yes.
Section 407 of CRPC into bracket since repealed and substituted by paritaria provision contained in PNSS 2020. Quote ends. On being asked, it is fairly submitted by the Learned Counsel that the allegation and FIR was at Umar Court, and according to the GR has been the Umar Court no at Dabuga. At Dabuga. And accordingly, the matter is pending before the court of Umar Court. Court at Umar Court. Court at Umar Court. Stop. It is submitted that the petitioner's residence is at about 140 kilometers at Dharmagad.
Thermogod, yes.
At Dharmagad, for which he is facing difficulty. Whether the place of residence of accused can be a factor for transferring a matter becomes the issue to be delved into. Doubt difficult and lekhi debe jaha to mu to correction kari do. Delved into in the present case. But the learned AGA submits that earlier the petitioner has approached this court in CRLMC number 3728 of 2025. In the said proceeding by the coordinate bench by order dated 10/12/2025 has been pleased to direct the proceeding pending before the
Paragraph 4, man.
pending before the honored JMFC Umar Court within
As expeditiously as possible. Without
as expeditiously as possible. It is submitted that after a direction is issued by this court for expeditious disposal, if the prayer for transferring the matter is allowed, that would be in conflict with the said earlier direction, which was issued as prayed for by the petitioner. The matter stands adjourned. To be listed in the week commencing, Mr. Ponda.
Week commencing, my lord, 23rd,
23 March.
23 March.
Week commencing 23/2024.
Published.
Yes, please.
Item 8.
Yes.
No difference.
You are Mr. A.
Abhijit
Mohanty.
Mohanty, my lord.
Mr. A. Mohanty for the petitioner.
Yes, the petitioner is the wife of the opposite party, my lord. Yet the petition has been filed for transfer of divorce proceeding by its CP number 413 of 2023, which was pending before the London Judge Family Court, Baleshwar. And other three proceedings are pending in Baripata, my lord. One is the GR case, my lord.
Other three proceedings you have filed.
My lord, I have filed, my
So
lord.
how that can be a criteria?
My lord,
You have chosen your place of prosecution,
my lord.
and he has chosen his place. So that cannot be a criteria because you have filed some cases. You go on filing cases usually. 5-6 cases against your husband.
It is,
And that is criteria for transferring matters.
my lord, I
You
have
have to
filed.
say something else other than filing cases.
There is also the petitioner is a single lady, my lord. Only his father is there, my lord.
But she is quite efficient in filing cases. Single lady is so efficient in filing cases. How many cases he has filed?
He has filed one GR case, my lord.
Which section?
He has under section 498, 506, 30.
Single lady, it has not, she is so efficient in handling matters. She goes on filing cases. And while defending the divorce proceeding, it's and she is so capable that she is filing criminal cases. And while seeking divorce, she has to defend it.
Oh, my lord, when her husband was I have already annexed the affair, my lord. He was physically tortured by demanding it, my lord.
It's not a general discussion or debate competition.
No, my lord.
Like
When my,
it looks as if the great Chandubhai said that the court is the lawyer is interrupting the court in arguing, but you must argue some substance. Single lady launches 5-6 cases
and
against her
also
husband,
it is a distance.
and when she is to defend herself in the divorce proceedings, she becomes single and unable to attend any case.
And I have also
In all her cases, has she not attended to court, the court or not? Where she is the complainant.
My lord.
Is she not required to attend the court?
My lord, yeah, attend to court, but also the distance is there, my lord. Also, the life threat is there, my lord. He was going to from Baleshwar to Baleshwar. That nearly distance about 100 kilometer, my lord.
Baleshwar to Baripada, have you ever traveled, sir? Actually, never make a erroneous statement. That is not your job. You are a lawyer.
My lord.
Have you ever traveled Baleshwar to Baripada?
My lord, from
Then why you are saying,
on, my lord. It is
saying 100 kilometers? You should not.
from his home.
Even if it is 1
It
kilometer,
is,
your job is to say 1 kilometer. You can't say 100 kilometer. Please appreciate that.
my lord, it is nearly
That
about
is, you are a
70
lawyer.
kilometers.
You are a lawyer. You have to be, you are officer of the court. No difficulty in arguing that Baleshwar to Baripada is 1 kilometer. I am facing distance. Difficulty. You should have that much of, what you call assertiveness. When the CP was filed,
My lord, CP was filed on
2023. When you started filing cases,
17/7/2023, my lord.
when you started filing cases against your husband,
I don't know. Once I have filed on judgment have been passed on 13 December 2024. I have filed the lost the FR on 10/8/2023, my lord. Page number 9, my lord.
and I'm not asking the pacer, I'm asking the date.
My lord. I have registered the FR on 10/8/2023.
So much after the filing of the CP. No case, sir, no case. This kind of jurisprudence has not evolved. Because the wife is single and five, 6 cases against the husband. All the cases have to be transferred where she resides. You appear and you obtain, go for this ICT. From Baripada, you can always appear before the trial court. No difficulty. If it is possible,
My lord,
file that application.
if my lord, the wife should be appear through BC, my lord.
Seek for legal aid, seek for VC.
My lord.
I'm not the trial judge. You must understand.
That liberty may kindly be granted, my
Absolutely no difficulty. You file a memo to that effect. I'm passing it over. I'll pass that order. That if you move the application for conducting the matter in ICT facility, that
my lord.
at times your legal strategy becomes counterproductive. You are witness in so many cases, informant in so many cases, and you are saying that you are facing difficulty in appearing before the court, and that in a civil proceeding.
My lord.
You file the memo, write it down. I am just passing it over. Next matter.
May I please?
Yes, please. So Haripada Mahanti for the petitioner, opposite party black. Yes, Mr. Mahanti.
My lord, here in the transfer petition, I am seeking a transfer of the CP number 1247 of 2025, which is an application under Section 9 of the Hindu Marriage Act, preferred by the husband, from which is filed before the learned judge, Family Court, Bhubaneswar, to Berhampur. My lord, before I take your lordship to the facts of the case, may I take your lordship to Section 19 of the Hindu Marriage Act? My lord, that is the provision which prescribes the jurisdiction before which any petition under the Hindu Marriage Act is to be presented. The language is such: court to which petition shall be presented. Now, my lord, every petition under this act shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction. There are 4 clauses. Now, my lord, the first is marriage was solemnized, or so there is 3 more ors. Here, marriage was solemnized in.
Can you complete?
Yes, ma'am. The respondent at the time of presentation of the petition resides. Respondent is me. Now, my lord, 3, the parties to the marriage last resided together. Now, more relevant, 3A, which has been brought in by way of an amendment, in case the wife is the petitioner, comma, where she is residing on the date of presentation of the petition, or 4, the petitioner is residing at the time of presentation of the petition in a case where respondent is at that time residing outside the territories to which the act extends, or has not been heard of as being alive for a period of 7 years. Now, my lord, I pause here. Para 4 and para 3, if your lordship see.
No, straight away come to the point. What is your argument?
No, my lord,
That the petitioner who has filed section 9, the husband,
yes,
does not certify 1, 2, 3.
1, 2, 3, 4.
Nothing is satisfied.
No.
Nothing is satisfied.
No, my lord, I would answer that question if your lordship.
No. It is your fact how you will answer. You have to assert that.
Assert.
So why you have to say that Bhubaneswar, how is not satisfied? You tell that.
Yes, my lord, that's what I am. But at the first, the marriage.
The marriage is not solemnized at Bhubaneswar.
No, my lord.
Then
in his own pleadings. The respondent at the time of presentation of the petition, it is also respondent is the wife.
You say that.
My lord, he has annexed the petition.
Okay, you say that you don't reside in Bhubaneswar.
No, my lord, he is also written that.
Then 3.
3. The parties to the marriage last resided together. In his petition, he has said it is Bangalore.
Straight away say that parties, you are arguing on the reverse.
No.
You are saying parties did not last reside in Bhubaneswar.
Yes, my lord.
So then come to the next point.
4. The petitioner is at the time of is residing at the time of presentation of the petition. It doesn't stop there, my lord. In a case where respondent is at that time residing outside the territories to which the act extends. So, my lord, here the clause 4 says.
Don't explain me, sir. This is not a law class. You have to tell me that the petitioner, whether is residing in the territory of the petition or not. I am not asking you to explain to read and explain section 19.
Then mu sait pe ko.
Apna say fact apply karantu kuhantu straight away.
Fact hala, my lord, the para 4 clause 4 hala. Petitioner is residing at the time of presentation of the petition. My lord, this should apply only when in a case where respondent is outside the jurisdiction of the act. So mu sait pe I was explaining that, my lord. My lord, may see that. Para 4, subclause 4 and 3 are totally different.
So what is your case?
My case
is in Bhubaneswar, what do you say?
Bhubaneswar, no part of cause of action has arisen. None of the clause 1, 2, 3 and 4.
What do you say, sir? Look, what is the petition?
Yes, my lord. I take your lordship to page 10.
No, to start from the other statement.
Hum usai 10 pa. My lord, say 10, page 10 nahi hai.
Look at the Khandagiri.
No, it is respondent.
See, this plea apna nebe trial re na.
No, my lord, may see 4.
Apna thike page 10 padile abo. Page 10 sangare padibe 19 dagu.
My lord, page 10 is the wife address is Barampur.
Petitioner pacharche apna wife puchche.
Petitioner Bhubaneswar. Bhubaneswar ta asudi 4.
Staying at Bhubaneswar, he cannot, you are saying.
No, it is not covered under 4. I may be wrong. Your lordship
may be correct. I may be wrong. That's a different issue. I cannot now prejudge the matter. City se plea niyantu. Maintainability ta nebe a point re trial court re.
Maintainability katha kohuni mala. Gotta line khal dekhe. I mala your lord
chahunti Bhubaneswar ru Barampur transfer kori.
Yes, mala.
On the ground that section 19 is not satisfied as far as Bhubaneswar is concerned. So tanga case dismiss he jibo.
Nahi.
Transfer darkar nahi.
Nahi. Transfer habo. Kahi ki mala.
Apna bujh par nahanti sir. You are a respondent there.
Correct.
The petitioner will decide the place of adjudication.
No, he cannot. As per 19, he cannot.
He cannot put
lekha
hai 4 the lekha. The petitioner cannot be filed court lekha hai.
He cannot
you are reading 19. The petition cannot be filed in these places.
He cannot choose. I gave an answer to I'm sorry.
I'm much more sorry because you are adding words. He cannot choose where it is.
where the act prescribes କୋଉ ଚାରିଟା ଜାଗାରେ ସେ କରିପାରିବେ
ବୁଝିପାରୁନାହାନ୍ତି ଆପଣ
ଆଜ୍ଞା
ସିଏ ଯଦି ପଞ୍ଚମ ଜାଗାରେ କଲେ
ଆଜ୍ଞା
ଆପଣ କହୁଛନ୍ତି କରିପାରିବେନି ବୋଲି ସେଇଟା କୋଉଠୁ ଆଣିଲେ
ନାଇଁ କରିପାରିବେନି କାରଣ କରିପାରିବେ
ଚେଞ୍ଜ କଥା ଆପଣ କହୁଛନ୍ତି Absolutely right.
ନାଇଁ I am wrong.
I have to record and reject it. You are saying
ଆଜ୍ଞା
that the petitioner cannot place a wrong place of prosecution. How can it be?
my lord then may I take I give that
ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ ହେଉଛି ଯେ ଆପଣ ଚାହୁଁଛନ୍ତି ଯେ ବ୍ରହ୍ମପୁରରେ କେସ୍ ଟ୍ରାନ୍ସଫର କରିବା ପାଇଁ ଚାହୁଁଛନ୍ତି
ଆଜ୍ଞା
but when you are asked that where the filing of Bhubaneswar it is prohibited there you are saying that it cannot be. So where is that word cannot be?
ନାଇଁ prohibited କାହିଁକି ନା
ଆରେ ସେଟା ପଢିବେ ନା କାହିଁକି ନା କହିଲେ
ନାଇଁ ମୁଁ satisfy କରିବା
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର filing at a wrong place touches upon the jurisdiction.
yes my lord
So obviously you take that plea, his case will be dismissed.
yes my lord
So who will decide that?
ନାଇଁ
High Court.
ସେଇଟା High Court decide
ଆପଣ transfer ପାଇଁ ସେଇଟା
ନାଇଁ transfer ପାଇଁ का ground ମୁଁ ସେଇଥିପାଇଁ କହିଲି ଯେ before I take a lordship to the fact on legal submission
ଆପଣ ସେଥିରେ respondent ନା applicant?
ସେଥିରେ
ହଁ.
respondent
Respondent.
yes my lord
Who will decide the place of prosecution?
under normal law CPC my lord nahi
Plaintiff decides.
my lord
So now it is a case of wrong jurisdiction. It can be territorially wrong. It
My
can
lord.
be jurisdictionally wrong.
correct my lord
Suppose he files a petition before the magistrate.
my lord
Now you are issued a magistrate issues a notice.
My
What you will do? You will say that you do not have the.
I am concerned ମୁଁ ସେଇଥିରେ
No, you know so many things, but you are insisting that,
No,
that there is a prohibition in section 19 in filing a petition.
my lord ମୁଁ prohibition
He cannot. You have said in so you can replay.
no I cannot dispute once your lordship is saying I cannot say that
No,
my
sir,
lord
not
ମୁଁ say
that.
ନାଇଁ ମୁଁ
Sir,
dispute
I am discussing your submission.
ଆଜ୍ଞା
So you have said that there is a prohibition in section 19 in filing a petition at Bhubaneswar.
nahi
Because
prohibition
he has himself said that he stays at Bhubaneswar. He has so now
sir,
then kindly read further. Kindly read further.
the petitioner is residing at the time of presentation of the
You are
petition
obsessed with the section. You are not reading the petition. First of all, if there is any prohibition, kindly bring to the notice of the court where it is prohibited. Straight away. Because it's a very good point.
ହଁ
But it can't be presumed.
ନାଇଁ prohibition ଟା ମୁଁ ଦେଖେଇ ଦଉଛି ଖାଲି ମୁଁ
Bhubaneswar, no. Upon 19, where is the prohibition of filing a petition at other places?
19 provides for 4 places my lord
No, you are not getting it, sir.
ନାଇଁ 19 ରେ ତ 4 places my lord
अरे ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି ଯେ filing in a wrong place where it is prohibited.
ନାଇଁ ମୁଁ ସେ
So
that is
then I have to reject that point.
no my lord
Then I have to read the petition.
my lord may I take your lordship to page 11
I am at page 11, sir. You have not gone there.
again page 11 ala the respondent father again proposed marriage and both the parties got engaged with marriage
No, page 11, para 1 out of the ଲେଖା ହେଇଛି.
nahi page 11 para 1 that the petitioner is the husband of respondent and their marriage was solemnized on 4th May 2022 as per Hindu rites and ceremonies and was held at Barampur Ganjam
So you must understand that petitioner has not hidden anything.
nahi
Please appreciate this also.
No,
This is
wrong.
what is happening.
nahi contention
you take your time, complete your submission, then I will start this.
nahi mu to bhalo
No, obviously.
once your lordship
When you are asked or tried to explain you, this is not my.
no I didn't understand the query I am sorry
No. You must have patience to understand.
I am sorry
The petitioner has not hidden anything. That he has said that yes, the marriage was solemnized at Barampur. But you
Yes.
have to read further.
yes ma'am.
So, yes.
that the first marriage proposal came in March 2021 but was not materialized for disinterestedness of respondent family
Set up a factual jantan.
nahi mu that the respondent's father the marriage and both the parties got engaged with marriage on 10th February 2022 third para ର last line
Data ki kon relevant ଆପଣଙ୍କର
nahi se
କଣ ତା ପୂର୍ବ ଯେତେବେଳେ ଆସିଲା ଆକ୍ଟ ଆସିନଥିଲା ନା କଣ
ନାଇଁ।
ଆପଣ ଯୋଉଟାରେ ଆପଣ ଯୋଉଟା ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ସେ ଟେରିଟୋରିଆଲ ପଏଣ୍ଟ କୋଉଠି ଅଛି ସେଟା ଦେଖନ୍ତୁ
page 12 that on 14/11/2022 the petitioner along with his parents traveled to Odisha for Lakshmi Puja but respondent stayed alone in Bengaluru and refused to come with him. Next para 12 again the petitioner after attending Lakshmi Puja returned to Bengaluru along with his parents
19 ପଢନ୍ତୁ
para
ଆପଣ ସେଇଟା ଛାଡି ସବୁ ପଢୁଛନ୍ତି ବେଙ୍ଗାଲୁରୁ ପୂଜା ପାରା 19 ପଢନ୍ତୁ
that since the parties resided together at Bhuvneshwar at petitioner's house for most part of the marriage. That is where I say it's a wrong
So
submission.
who will say that? Because you are saying it is gospel truth.
ନାଇଁ ସିଏ ପୁରା ସେଇଟାକୁ
ସେଇଟା ଆପଣ deny କରିବେ.
ନାଇଁ ନାଇଁ ମୁଁ
This is the problem with you today, as far as this case is concerned.
ମାଲ
You are saying 19 is incorrect. This court cannot presume that because you are saying 19 is
No, no,
incorrect.
no, say-
So you must understand that. So that is how I try to make you understand that when the petition is filed,
ମାଲ
effort is made to show that there is a jurisdiction. Then read para 19 again.
Para 19 that since the parties resided together at Bhuvneshwar at petitioner's house for most part of the marriage, the cause of action for dispute arose partly within the jurisdiction of this honorable court.
That is enough.
ନାଇଁ ସେଇଟା
So
ଯଦି
that satisfies 19(1). Now you are disputing that. This
ନାଇଁ
is not the place
91
for
ହଉନି ନା
dispute.
ସେଇଟା ମାଲ ମୁଁ ଯାହା ବୁଝୁଛି
ଆରେ ଆପଣ ତ ବହୁତ ଜିନିଷ ବୁଝିପାରୁଛନ୍ତି, ମୁଁ ଏତେ ବୁଝିପାରୁଛି।
ମୁଁ ବୁଝିପାରିଲିନି କହିଲି
ଆପଣ ଆଉ ଥରେ ପଢନ୍ତୁ ତାହେଲେ କଣ କରାଯିବ? 19(3).
the parties to the marriage last resided together ବେଙ୍ଗାଲୁରୁ ସିଏ
ନା
ଲେଖିଛି
ନା ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି, ଲାଷ୍ଟ ଅର୍ଥ ସେୟା ନୁହଁ। ଆପଣ 19 ଟା ସି ଯୋଉଟା ଲେଖିଛନ୍ତି
19
ଆପଣଙ୍କର କନଫ୍ୟୁଜନ ହେଇଗଲାଣି ଯେ ଆପଣ କହୁଛନ୍ତି ପିଟିସନର।
ନାଇଁ ନାଇଁ
ପିଟିସନର ଆପଣଙ୍କ ଆଡ୍ରେସ କଣ ହବ? ପିଟିସନର ଯେ କୋର୍ଟରେ ମିଛ କହିଲେ, ବୁଝିପାରୁଛନ୍ତି?
ହଁ।
ସେଇଟା that cannot be a ground for transferring the application.
ନାଇଁ ନାଇଁ ମୁଁ ସେଇ
So that cannot-
ନାଇଁ ମୁଁ ଫ୍ୟାକ୍ଚୁଆଲି ସେଇଥିପାଇଁ ମାଲଟ କହୁନି ମୁଁ ଖାଲି
Actually ନ କହିଲେ ତ ଲାଭ କିଛି
ନାଇଁ
ନାହିଁ।
ବେଙ୍ଗାଲୁରୁରେ ଲାଷ୍ଟ
ସେଇଟା
ରିଜାଇଡ୍
ଆପଣ
କରିକି
କାହାକୁ କହିବେ? ମତେ କେମିତି କହିଲେ କେମିତି ହବ?
ନାଇଁ ଏଇ
ସେଇଟା 19 ରେ
application ପଡୁଛି
19 ରେ ଲେଖିଛନ୍ତି ନା।
ନାଇଁ ସିଏ
19 ରେ ଆପଣ ଯୋଉଟା ସେ 19 ରେ ଲେଖିଛନ୍ତି, you are disputing that. Fair enough.
ମାଲଟ
For disputing that, you have to file WS there, dispute his claim. Not seek transfer that 19 prohibits filing of application at Bhubaneswar.
ନାଇଁ ମାଲଟ
Which is the leading decision on this?
ମାଲଟ
There are decisions.
ୟେସ୍ ମାଲଟ
Yes, there are decisions. This is a point that is argued and over-argued in all cases.
ମାଲଟ
Last line of defense, you dispute the jurisdiction.
ୟେସ୍ ମାଲଟ
So the case gets over, CP. So you have to argue that in the trial.
no malat that is there malat itare ke to mane my malat
Your point is well taken that 19 is a prohibition for filing a case at Bhubaneswar. That has to be rejected.
malat
Yes. What is the next point?
no malat if that because on facts also malat if that's the malat I cannot
No, it's not the facts. It is my interpretation. Facts are
no mu say
Because you cannot also interpret.
talking of the interpretation
That
it's not my intent
I cannot interpret. No. Please don't take it personally.
nahi
This is a
mu
legal
say
discussion. So when you say 19 is a bar for filing a petition at Bhubaneswar, he describes his address at Bhubaneswar, files address statement before the trial court. Para 19 is very clear.
malat
The court cannot examine like this.
malat
That so and so represented by so and so says that he is not staying in Bhubaneswar.
malat
That is your defense. That is your defense in written statement. That this court doesn't have jurisdiction.
malat
You have to raise that.
malat
The petitioner husband is before the petitioner wife is before this court. The petitioner is the wife in the marriage is before this court seeking transfer of. You take your seat. I'll take some time in between.
malat
Seeking transfer of the CP number 1247 of 2025 pending in the court of the Lorded Judge Family Court to Bhubaneswar. To the Lorded Court of the Court of Lorded Judge Family Court Barampur. Had Lorded counsel for the petitioner extensively. The Lorded counsel relies on section 19 of the Hindu Marriage Act. To submit that the petition cannot be initiated at Bhubaneswar. That is before the Lorded Judge Family Court as to Bhubaneswar. In view of the provisions contained in section 19. For convenience of reference, the said section is reproduced herein. Chapter 5, Jurisdiction and Procedure. Para. It is submitted that none of the four conditions are satisfied in case of the petitioner. In case of the opposite party who has filed the CP. The lauded counsel for the petitioner was requested to go through the petition, filed copy of the petition filed before the lauded Judge Family Court Bhubaneswar at para 10, wherein the address of the petitioner has been given as Lekhidevi Purana. Prosecution of conduct Neki, Purna Odisha. The paragraph 1 and 19 of the petition are reproduced herein. Referring to paragraph 19 of the petition in the CP, which was brought to the notice of the learned counsel for the petitioner, is submitted that the amendments made in paragraph 19 of the petition are not correct. It is submitted that the petitioner, wife and the opposite party husband did not stay at Bhubaneswar. It is further submitted referring to para 11 of the application that the petitioner and the petitioner wife and opposite party husband stayed at Bengaluru. Apparently, the petitioner is raising an issue of territorial jurisdiction, which it shall be open for her to refer to. Matter to Daki Bully pass over. Petitioner, if so advised to raise before the court, that is not just family court 2. At this stage, this court cannot express any opinion regarding the said issue, as it requires evaluation of the facts and would be a matter of evidence to be adduced by the parties. पढ़ेले और गुड़ा गुड़ी खोल रहे बाहर Section 9 of the Civil Procedure Code in Part 1 provides for jurisdiction of the courts and res judicata and reads thus. 9 reproduce कर देंगे. Therefore, at the stage of filing of a suit, maybe before a court which lacks territorial jurisdiction due to the provisions of statute, it cannot be said that the court cannot try the said suit unless there is any express bar reading of section 19 of the Hindu Marriage Act makes it abundantly clear that the said section limits the territorial jurisdiction of courts to entertain petition under the Act. However, the said section cannot be read and interpreted to conclude that it is a bar for filing of petition, say language used to be, filing of petition under the Act before a particular court. On being asked, the learned counsel for the petitioner fairly submits that apart from raising the issue of territorial jurisdiction, seeking transfer, the petitioner does not seek transfer on any other ground. In view of the above, at this stage, it cannot be held that Section 19 is a bar for filing the suit as has been done. That is CP number 1247 of 2025 under Section 9 of the Hindu Marriage Act 1955 before the learned Judge Family Court dash Roman 2. So, accordingly, the petition is disposed of. However, it shall be open for the petitioner to raise all such grounds that would be permissible under law while filing her written statement. She may agree also. You never know that she may agree for. I think she in this case she agrees for divorce. Otherwise, why she would seek for the transfer? Because one transfer from Bhubaneswar to Berhampur, it remains a divorce 13 petition.
No, it's a 9.
Sorry, section 9.
Malam.
She wants to register 9. So she may be wanting to divorce also.
At this stage, I cannot say that.
Anyway, so that is how I am saying it. I am discussing after that. What like it? In statement before the Judge Family Court 2, out ICT 2 paragraph. If so advised, she can file for remote location hearing, remote appearance, and all those things. ICT for one paragraph is there. She has to move the court will provide that. But are you sure that you are not pressing any of, because you told me that is dictated?
No, Malad, that I was just, because I didn't want to interrupt, Malad, that I am not pressing any other ground. That may not, your lordship may not reflect.
No, then the problem is that then how I dispose of?
No, kahinki na once.
19 is a bar koile. That is rejected.
Bar koi notli. Maybe mu bhul कहली. Bar koi notli. सेइतरे आसुनी.
तुरंत आपण bar कोतु बा maintainable कोतु, not maintainable.
1 2 3 4 रे आसु नथला बोली मु कहि.
सेटा केमति मु डिसाइड करबी पारा 19 पर.
सेट पे का मु मालट आउ तादरे.
पारा 19 पढि नथिए. When you accepted the brief, you should have read all the proceeding. When your client told you this story that we have never said, then she has to answer para 19 before the court, and only the family court that para 19 is not correct. Obviously, and lack of jurisdiction is a very good ground to take. ground नेबे कोन जदि कहिथान ताले have to consider.
नहीं मतलब खाली से जो no other ground तक वो मतलब I may say that your lordship may not reflect. It is because
but you are saying that it is understood that there is no other ground.
नहीं why I did not say. Before me, there were 2-3 petitions which your lordship was hearing. I didn't want that those grounds again for the repetitive sake. I didn't want to press. Say same thing.
There can be obviously filing of 5 criminal cases against the husband makes it good. Set out a bhala ground bill so the
नहीं मु सेटा किंतु
for example दोची so सेटा तो अलग कथा discussion होतला
but नहीं तो ballot what I know
ठीक ट्रांसपोर्ट बाइक
मु सेतरे ballot सेही जिंसो गुळे को आउथरे हबो से I don't want to खाली सेही लाइन टा I
सेटा डिलीट हेजो ठीक है
आगे published
yes next
Item 10.
Vivekananda Jena for the petitioner. Yes, Mr. Jena.
Petitioner.
Passover, one second, what a Passover.
Okay.
ठीक है.
There's a petitioner, your lordship, which is challenging the order passed by the Lok Adalat, your lordship, where without making her a party, the opposite parties have managed to take a decree of compromise decree, your lordships. That order is being challenged, your lordship.
Have you examined the case law on this?
Yes, your lordships.
Those three decisions.
Again,
You
Bhargavi
can notice, but maintainability will be kept open.
Again.
So Vivekananda Jena for the petitioner, opposite party blank.
State of Punjab versus Jalal.
After that also.
Bhargavi Constructions.
After that another one.
24 rows it आपने देखी क्या?
Bhargavipur I would have said, Justice, Honorable Justice Pardiwala. If you are not made a party, I think appeal is maintainable. Even it got read petition.
Lok Adalat through which no appeal lies under section 21.
Read Jalor Singh.
Jalawar Singh.
Jalor Singh says is very, State of Punjab versus Jalor Singh is very clear that in certain cases appeal is also maintainable.
But
I also do case because you are not a party, so you have been awarded to be made a party or non-gender necessary party.
there are other facts also, your lordships. But
Yeah, you are a first of all appeal file leave neki.
again,
If you read Jalor Singh makes it very clear that in certain cases when there is no agreement between the parties, no settlement deed between the parties, or the court has not relied upon any settlement, then it is an appellable order. It's very clear. I am not asking you the question, sir, 226 maintainable or not.
again.
My understanding is that 226 is maintainable, appeal is also maintainable. Those larger bench decision of Jalor Singh, followed in Bhargavi. But in certain cases, appeal is also maintainable.
Lordship.
Where it is not based on a agreement between settlement between the parties.
Settlement.
Roughly. I mean that would be the ratio.
Here the petitioner was not at all a party.
So that's how then how do you say that it is
There is
there
no
is a settlement between the party, between the petitioner and the other side?
Exactly. There is no settlement. So also there was a suit filed by the present petitioner which was allowed for permanent injunction.
Let us see.
Against
let them take notice now. Because at least I have been assisted by all of you to at least that extent. You take your seat. I'll take some time and dictate. The petitioners are before this court challenging
one petitioner.
The petitioner is before this court challenging the award dated 1/3/2016. Order dated 1/3/2016 passed by the learned judge, learned civil judge Soro in CS number 137 of 2015. लोक अदालत कोटा है कहली
Lok Adalat, your lordship, that is
52. एक दिन ना बाद दिन कोड़ा चैलेंज করছো
एक दिन is
1/3 and 2
एक दिन is the order
2016.
that compromise was accepted.
Correct. Both you are challenging.
Right.
In CS number लिख ले. By the said order dated 1/3/2016. Please take your seat. 1/3/2016. The petition under Order 23, Rule 3 of the CPC, filed by the parties to the suit, parties to the CS, seeking a compromise was accepted. It is submitted there. It's thereafter, by order dated 12/3/2016, the compromise petition was accepted. Filed out. By order dated 1/3/2016, petition filed under so and so by the parties to the litigation was taken on record. Was taken on record. By order dated 12/3/2016, the compromise petition was accepted. The suit was decreed finally in terms of the compromise. It was further directed that the compromise petition and sketch map shall be part of the final decree. Stop. It is submitted by the learned counsel for the petitioner that the suit suffers from non-joinder of necessary party. The petitioner herein is the petitioner herein is vitally interested in the suit property, being a
Purchaser from the ancestors of the present opposite parties.
Being a purchaser. Kindly take your seat.
Since 1990.
ଆପଣ ଏଟା ପାସ ଓଭର ହେଇଥିଲା ଆପଣ ଛାଡି ପଳେଇଲେ ସେ ତାକୁ ବସନ୍ତୁ ଗୋଟେ ସେକେଣ୍ଡ. Being a purchaser from the predecessor in interest.
Predecessors of the present opposite parties. Where the
from the predecessor in interest of the
present
opposite parties who were parties in the civil suit.
dated 1998. Where the present opposite party number 1, 4 and 6 were
in view of the law laid down, keeping in view the law laid down by the Honorable Apex Court in Jalor Singh, Punjab versus State of Punjab versus Jalor Singh, Bhargavi Construction, and
Bhargavi Constructions.
Bhargavi Porota outage. And so and so. Harta call. Bhargavi Construction and so. The question of admissibility of this petition and maintainability is kept open. We should notice to the opposite parties along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 7 days. Within 7 working days. Now, how many? 7 working days. List after SR. Liberty to mention.
There is an
ଆପଣଙ୍କର share କେତେ ଏଥିରେ?
the entire no, not entire.
Let them come. That will create that will open a Pandora's box now. If I start discussing that.
Paragraph 3 I have stated, your lordships.
Okay, let us see. Let them come.
IA, your lordships.
Correct, sir. IA ପାଇଁ ତ ପଚାରୁଛି ଆପଣଙ୍କ share କେତେ?
Paragraph 3 I have given.
ସେତିକି hint. You are sufficiently experienced. I mean, I rate you that way. ଆପଣଙ୍କ share ଯେତେବେଳେ ପଚାର ହେଲା ଆପଣଙ୍କ share କେତେ କଣ ପ୍ରପର୍ଟିରେ ଆପଣ ବୁଝିବା କଥା IA ବିଷୟରେ କଣ ପଚାରୁଛନ୍ତି? IA number 2149.
ଆଜ୍ଞା
2179 ଭୁଲ ହେଇଛି. ଏବଂ IA number ଟା ଭୁଲ ହେଇଛି. କଣ 2177 ନା 79 କଣ ହେଇଛି? ଦେଖିଲେ ଆଇଟା କାଢି ଦେଖନ୍ତୁ. ଆଇଟା ନମ୍ବରଟା ପରେ ପକେଇବେ ନା. Hard learned counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. As an interim measure, it is directed that the final decree, the order dated 12/3/2016 and the final decree pursuant thereto, passed in civil suit number 137 of 2015, by a flag error. The Nani Bula
Initially,
ସେଠି ସାର୍ ମୁଁ ଦେଖାନ୍ତୁ
CMP was filed. Thereafter, it has.
ସେଟା ଗୋଟେ କରେକ୍ସନ ରେଟ୍ ରେ କରେକ୍ସନ ହେଇଛି ଚେକ୍ କରନ୍ତୁ ମୁଁ ଜାଣିନି ଆପଣ ବ୍ରିଫରେ କଣ ଅଛି
2177. Corrected to 2177. IA number
77
217.
ନା 79
77.
77 କଣ ଲେଖୁ shall not be given effect to without leave of the court. The petitioner as well as the opposite parties and others and others shall maintain status quo regarding nature, character, ownership of the property during pendency of this petition. List after the item dispose of for the law. Like also the list after is liberty to mention. It's a Mahanti for the petitioner. The learned counsel for the petitioner is hard at length. You take your seat. I'll dictate the order in your presence. Kindly take your seat. The petitioner wife is before this court seeking transfer of the petition CP number 413 of 2023 from the Court of the Learned Judge Family Court Balasore to the Court of the Learned Judge Family Court Baripada, Mayurbhanj. It is submitted that though Baripada and Mayurbhanj are adjacent districts, the petitioner is facing difficulty to attend the matter at Balasore. It has been further stated that the petitioner has initiated several cases against the opposite party husband in the marriage. Petitioner wife has initiated several cases against the opposite party husband in the marriage at Baripada. Therefore, the petition filed by the husband in the marriage under section 13 of the Marriage Act should be transferred to Baripada. In considered view of this court, the wife opting to file as many cases against the husband at a particular place cannot be a ground to transfer the petition filed under section 13 of the Hindu Marriage Act seeking divorce. If the learned court where the divorce application has been filed, where the section 13 application has been filed, has jurisdiction as defined under section 19 of the Hindu Marriage Act. At this stage, the learned counsel for the petitioner files memo of date, which states thus. The memo is taken on record. Scan copy be updated. The petition is disposed of. It is directed that ICT paragraph the Purana Lekhi. You make an application. Whatever you want, remote, like you can utilize the BC facility for deposition, BC facility for appearance, wherever possible. Yes. Yes, next.
11.
Petitioner now. Non appears for the petitioner when the matter is called. The matter is adjourned to
commencing 2-3.
recommencing 2-3-2026. अरे दुई पर हॉलिडे गला आपण 5 करियो holiday record लिखियो 2 has been notified to be holiday. Yesterday bar resolution. Yes. Yes, next.
12.
Petitioner none. None appears for the petitioner when the matter is called. The defects as pointed by the SR we remove within 7 working days. List in the week commencing no. That's what.
No.
Not it.
May Lordship.
Yes, please. You are Mr. Mahapatra. Mr. Ajit Chandra
BK Panda.
Mahapatra for the petitioner.
BK Panda.
Mr. PK Panda.
BK.
Panda. Sorry. Mr. BK Panda for the petitioner. IA file kariye.
3 days time.
30. Mr. BK Panda for the petitioner. SR date jana achi kebe hitla.
Sorry.
This is so dekhi ready hava katha na.
Last 3 days I am
As
also
far as-
filing in high.
ଏବେ ଏଇଟା ତ ନେଟ୍ ରେ ଆସିଯାଉଛି ନା ଆମେ ତ ଯାଇକି ଫିଜିକାଲି ଦେଖୁଥିଲୁ ଏବେ କଣ ନେଟ୍ ରେ ପୁରା ଆଭେଲେବଲ ହେଲାଣି
ଆଜ୍ଞା।
ଆପଣ ଦେଖିପାରିବେ
ଆଜ୍ଞା।
as per the staff report dated 27/10/2027 ବସ୍ ତ ହବ
टाइटल खाली आरपीएफ
କେବେ ଡେଟ୍ କେବେ ଏଟା 19 27/10/21 dated 27/10/21 the nomenclature of the petition has to be CRLMP.
Yeah.
Para. The learned counsel for the petitioner submits that he may be granted further time to take necessary steps for change of nomenclature by filing appropriate application. Para, accordingly, steps be taken within 10 working days for filing of the IA. List in the week commencing 16 23. Yes. Yes, next please. Yes.
I missed my item 11.
Yes, please. 11 रे कौन हला कहले?
May please your lordship, I am appearing on behalf of the petitioner,
Yes. Appo na?
Adyasha Mahapatra.
You have power here.
Yes,
Yes, A Mahapatra for the petitioner. Yes, please.
Your lordship, this writ petition is filed seeking the transfer of MAC case number 100 of 2023 from Burger Tribunal to Puri.
How does it help? How does it help, madam?
Pardon my lordship.
Because you must understand the cause in a case like MSCA, the vital evidence is at the place of occurrence.
Yes, your lordship, but
So if you transfer the matter to another place, that would not help any of the claimants.
I agree, lordship, but the issue.
Then you should not. You must counsel the person who is thinking that because the accident, suppose I can tell you, it can be a interstate also. Something happening, unfortunate accident happening for a pilgrim traveling in other state.
Yes, your lordship.
Why it is the initiated at that place? Because the vital evidence and witnesses are there. That you must consider.
But lordship, the
Because by this you are frustrating the purpose of expeditious trial actually. That should be the prime concern.
yes, your lordship. But lordship, the wife of the deceased person.
This difficulty is there. Somebody's, the accident takes place in Burger. The
Yes,
person, the claimants, the legal heirs, descendants, they stay in Puri.
Yes, your lordship.
But if you start conducting the trial in Puri, then for every appearance there will be adjournment.
But lordship,
Because even the vehicle cannot be produced, the local concerned records, because those are vital evidence in case of a motor accident.
yes, your lordship.
Police papers, everything becomes so crucial.
But lordship, the
And suppose, let us assume another aspect. Suppose they agree for a settlement in local adalat. It will be still more difficult. Because the insurer, the vehicle owner, the registration authority, the police, everybody is there at Burger. you take adjournment.
Okay.
Let's नहीं सिर्फ इतना appearance लिखिए. By filing the application, the petitioner seeks transfer of MSC case number 100 of 2023. And now actually there is no limitation as the law has evolved. In MSC case, there is no limitation.
Yes.
And I think it can be filed at any place. But once it is initiated and it has reached a level where it can be adjudicated, you should not seek transfer.
Oh, pardon me, Lordship, but when it was initiated, the petitioner and the opposite party number 3 and 4 residing at the place of Burger. But after the demise of the husband, the petitioner is driven out from her in-laws' house, and currently she is residing in her.
It's not a matrimonial case, madam.
I agree, Your Lordship, but the
Suppose she is seeking some matrimony, I mean, the other matters, some she wants to, file a suit. This is
There
not a
is a
matrimonial
DV
case, it's a motor accident claim.
there is a DV case which was pending before the Nimapada JMHC Puri. So it
So actually, this matrimonial transfer concept has infected this MSc also now. This is a case of what you call transfer of momentum, or that way also. Due to impact, momentum is transferred.
because of the in-laws, he is unable
The person of the vehicle gets injured because of moment of transfer. Now the case is getting injured due to moment of transfer. This
Yes,
concept
yeah.
has been borrowed there. Only. Now pending before the motor accident claim tribunal, Burger.
Burger.
First motor accident claim tribunal, Burger. It is not disputed before in the petition that the accident took place on 5/9/2023 at Monopali NS26 under the Borapali PS police station. Now, therefore, the cause of action, all the evidence and witnesses are within the territorial jurisdiction of the tribunal at Burger. The learned counsel for the petitioner's adjournment, whether to address as to whether by transferring the to Bhubaneswar,
Puri.
to Puri, any purpose will be solved in expeditious disposal of the matter. It will be a huge struggle, madam. Most of the cases are getting entangled in time because of non-availability of witnesses. You must understand that. And if you have any difficulty in appearing at Burger,
Yes, Your Lordship.
you go for this ICT facility, because everywhere now it is provided. There is a remote location VC, remote deposition, everything. Yes. आपनका शेयर भी बढ़ी जीवन पूरी आसी गले आपनकर जति एज ए लीगल हेयर जति पाया कथा पाइबे.
No, Your Lordship, the
So
question.
माने बेसिकली द कांसेप्ट इज somehow it's lot of confusion.
Yes, yes.
मोटर एक्सीडेंट क्लेम्स रे आपनकर जेतेबेले अपोर्शनमेंट हो आपन जति पाया कथा पाइबे बरगड रे जा पुरी रे भी शेयर मिलिबो. रादर आपन बरगड रे फाइट करिया कथा काहे कि द केस विल बी 45.
Because Your Lordship is unable to look out of the cases because they are
Seen not. You see, I mean, because they will be damaging the case. They damaging the case will be to their detriment also. If they are the claimants, more the claim, more the benefit to all of you. Even if you start fighting and quarreling over that. But the quarrel is over a share or for the amount? Quarrel is over a share. So more the amount is better. That you can ensure at Burger.
I agree, but it is difficult for her to travel Nimapada, then Puri, then to
But we
Bangalore.
can, now this direct payment actually, direct payment to the account also. They can't take away the money.
I
I
agree.
mean, what you are saying is absolutely correct. From my little experience, I have seen this. The entire money being kept by someone and distributed. Those days are gone. Even the local level also, it is the last line it is hitting, subject to apportionment between the parties, the claimants. It is also there. Law has evolved that way. Yes, next.
Adjournment date, sir.
केबे डेट कले
30 दिन
केबे आसले हम 30 दिन वीक आसीबो ना आगुरु आसीबो
Sir, ଯଦି ଆଗରୁ ହେଇପାରିବ but
आगुरु कर दियो लिस्ट इन द वीक कमेंसी 23 दिन
highly blessed.
yes please
15. That's 40.
14 ना 14 डका आइतला बोले
14.
ठीक है कंफ्यूजन हेगला से जो मेंशन से एक्चुअली ताको मैटर नबा कथा नो कि से मेंशन कले तो मो टेक अप कर देली अजित और को सीरियली को जाय आपण को सर आपण मैटर केते
15 माइलर
आपण को 14 सडन आपण को 14
14
सी 11 टा मेंशन करते 14 तो 14 author डाकिबे 13 जाय जाय आपण को 13 सर
हमरो 15
just give us a moment 14
आगे 16 टका
yes Mr. Sadangi you are for 14 you are for the
OP number 2, my lords.
OP
Yes.
you are there for the petitioner
Your Lordship, I am for the petitioner.
yes please आपण को ना
Jyoti Priyadarshini Tripathi.
JP Tripathi
Again.
yes what do you say madam
Your Lordship, for this matter, we have received the counter, my lord. Only we have to file the rejoinder as well as objection to the IA filed for the vacation of stay. Your Lordship, I pray for only 10 days time to file both from my side.
Miss JP Tripathi for the petitioner so Sadangi you are appearing for
OP number 2, my lords.
P2
Yes, Sunita.
Anupam Das DK Patra there
My lords. I'm appearing on behalf.
no, I'm sorry I have opened maybe some another brief I'm sorry I have opened another this is 14
My lords, I'm appearing on behalf of Mr. Anupam Das.
right Mr. Arpit Sadangi for OP2 along with Anupam Das the learned counsel for the petitioner submits that she will obtain instruction in response to the counter
Your Lordship, we have received the counter.
from the counter received
Only to
and
file.
file rejoinder if so advised and placed for further time. She also submits that stop. She also submits that she will also file objection to the petition seeking vacation of interim order.
Again. I
Stop.
have respections.
Accordingly, the matter shall be listed in the week commencing
Your Lordship.
6/4
Short
2026. Yes. Yes, please next.
Obliged, my lords.
May I please, my lord? My lord, I am for the opposite party 2 and 3, my lord. Wife and daughter, minor daughter, my lord. I have filed a IN number.
I want to file objection to his petition. The copy was served on me only yesterday.
I have filed.
Maintenance stay ନେଇଛନ୍ତି କି
Maintenance?
ଆଜି vacation stay ହେଇଯିବ
No, maintenance I am paying. Not
ଦଉଛନ୍ତି
I am paying. I have paid also 1 lakh intact to initial order 1 lakh. Thereafter I am paying on 600. No, ଆମେ ସବୁ ମାସରେ ପଇସା ଦଉଛୁ.
correct sir
And in between the
I mean sir that is the law it is very clear so best sir said that
so we are the petitioner, the husband is paying. And
ଯୋଉଥିରେ ମେଣ୍ଟେନାନ୍ସ ମିଳୁଛି ସେ କେସ୍ ଆଉ
ନା ସେତେ କଣ ହେଇଛି ମାଲିକ ମତେ ଗୋଟେ ମିନିଟ କହିବି 12,000
ଆପଣ ଯେଦିନ ଚାଲିବ ସେଦିନ ମେଣ୍ଟେନାନ୍ସ ପାଇବେ
ନା ମାଲିକ
ଡାଇଭର୍ସ ସରିଗଲାଣି
ଗୋଟେ
ଭେରି ସ୍ମାର୍ଟ
ମୁଁ ଆପଣଙ୍କୁ କହିଦେଲା ପରେ ଆପଣ ଜାଣିବେ କାହିଁ ଗାର୍ଜେନ 12,000 ଟଙ୍କା ମେଣ୍ଟେନାନ୍ସ ଦିଆଯାଇଥିଲା ୱାଇଫ ଆଣ୍ଡ ମାଇନର ଡଟର ପାଇଁ ହଜବେଣ୍ଡ ଚ୍ୟାଲେଞ୍ଜ ବିଫୋର ଦିସ୍ ହନେବୁଲ ହାଇକୋର୍ଟ 12,000 ଟଙ୍କାକୁ 7,000 କରିଦେଲେ ସେତେବେଳେ ବେସିଂ ଅନ୍ ଭିଉ ଯାତେ ହି ହଉଛି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ସର୍ଭେଣ୍ଟ ସେ ସାଲାରୀ ପାଉଥିଲା 20,000 ଟଙ୍କା ମୁଁ ବର୍ତ୍ତମାନ ସାଲାରୀ ସାର୍ଟିଫିକେଟ ଫାଇଲ କରି ଆପଣ ଫାଇଲ କରିଛି ଆନେକ୍ସର 48,000 49,000 ପାଇଲେଣି
ମୋର ମାଜିଷ୍ଟ୍ରେଟ ନା ହାଇକୋର୍ଟ
ମାଇଲଟ
ମାଇଲଟ ଆରେ ସେଇଟା ଆପଣ କୋଉଠି ଫାଇଲ କରିବେ?
ସେଠି ଅଲ୍ଟର
ନା ହନରେବଲ ହାଇକୋର୍ଟ ବା ଗ୍ରାଣ୍ଟେଡ ଷ୍ଟେ ମିଲଟ
ଏନହାନ୍ସ ମୁଁ କେମିତି କରିବି? ସେଟା ମୋ ପାୱାର ଅଛି।
ନା ଷ୍ଟେଟା ଭାକେ ଆଇ ଫାଇଲ ଦ ଭ୍ୟାକେସନ ଅଫ ଷ୍ଟେ ମିଲଟ
ଆରେ ସାର୍ ଆପଣ ଯଦି ଏନହାନ୍ସମେଣ୍ଟ ଫାଇଲ କଲେ
ନା କରିନାହିଁ
କରୁନାହାନ୍ତି ମୁଁ କଣ କରିବି ତାହେଲେ?
ଏଇଠି ବା ଆପଣ ଷ୍ଟେ ଦେଇ ଦେଇଛନ୍ତି ରିଡ୍ୟୁସ କରିଦେଇ ଏମାଉଣ୍ଟ ଟାକୁ ଷ୍ଟେ କରିଦେଇଛନ୍ତି।
ଆପଣ ଆପଣ ଯଦି ଦିଟା କଥା ସାର୍ ଆପଣ ଏନହାନ୍ସମେଣ୍ଟ ଚାହୁଁଛନ୍ତି କି 12,000 ଚାହୁଁଛନ୍ତି ବୁଝିପାରୁଛନ୍ତି? ଯଦି 12,000 ଚାହୁଁଛନ୍ତି ତାହେଲେ ତ ଠିକ ତାହା କହିଲେ ଠିକ
ମୁଁ 12,000 ଚାହୁଁଛି
ଆଉ ଯଦି 12,000 24,000 ଚାହୁଁଛନ୍ତି ତାହେଲେ ସେଠି ବାଇଷ୍ଟାଣ୍ଡ ଫାଇଲ କରିବେ ଫ୍ୟାମିଲି ଜଜ୍ ଫାଇଲ କରିବେ
ନାଇଁ ନା ଭାଇ ମୁଁ
125 ଡୋମେଷ୍ଟିକ ଭାଇଲେନ୍ସ ଡିସିଜନ ପାଖରେ ହଉଛି ନା ମାନେ ଫ୍ୟାମିଲି ଜଜ୍ ପାଖରେ ଆଫ୍ଟର ଜଷ୍ଟିସ ଭର୍ସେସ୍ ନା
ମୁଁ 12,000 ଚାହୁଁଛି।
ଆପଣ 25(3) ଫାଇଲ କରିପାରିବେ 125 ରେ ବି ଫାଇଲ କରିପାରିବେ 125(2) ଯୋଉଟା କି ଏବେ ଆମେଣ୍ଡମେଣ୍ଟ ହେଇକି ଆଉ ଗୋଟେ ହେଇଛି।
ମାଇଲଟ
ଏନହାନ୍ସମେଣ୍ଟ ଟା ସେଠି ହବ ଆଉ ଯଦି ବାହାରକୁ ବାହାର ଚାହୁଁଛନ୍ତି ତାହେଲେ ଚାଲୁ କେସ୍
ମୁଁ ବାହାରକୁ 12 ଚାହୁଁଛି।
7,000 ପାଉଛନ୍ତି ତ ଆଉ କଣ?
ନାଇଁ 7,000 2 ଜଣ ପୁରା ମା ଛୁଆ 2 ଜଣ
ସାର୍ ଟିକେ ବଢାନ୍ତୁ।
ସାର୍ ଶୁଣନ୍ତୁ ଆକ୍ଚୁଆଲି ମୁଁ
ସାର୍ଟିଫିକେଟ ଫାଇଲ କରି
ଲେଟ୍ ମି ଲିସନ୍ ମୋ ଘରେ
ଆପଣ 12,000 ଟା ସମୟ କମେଇ ହବ
12,000 ନାଇଁ ନାଇଁ ସେଇଟା ମୁଁ କମା କଥା କହୁନି। I am not saying
hearing କରୁନି ସାର୍
ମୁଁ କଣ କହୁଛି
persuading like a mediator
ମୁଁ ଏକ୍ଜାକ୍ଟଲି ମୁଁ ଆଇ ଏମ୍ ସେଇଂ
adjournment
ଶୁଣନ୍ତୁ ଏଥିରେ
how do you sustain a order where the salary structure is clear?
ହଁ ସାଲେରୀ 41,000 ପାଉଛୁ।
ଆସିଲେ ହାଇଟ୍ରେମ୍ ଅର୍ଡର ପାଇଲେ ଠିକ ଅଛି ବର୍ତ୍ତମାନ ଆପଣ 12,000 ଆଟଲିଷ୍ଟ ଦିଅନ୍ତୁ।
ପ୍ରୋବ୍ଲେମ ଟା କଣ ଶୁଣନ୍ତୁ ମୋ ଘରେ ସିଏ ରହୁଛନ୍ତି ମୁଁ ବାହାରେ ଭଡାରେ ରହୁଛି
ସେଇଟା ଆପଣଙ୍କ ଚଏସ୍।
ନାଇଁ ସାର୍ ମୋ ଚଏସ୍ ଶୁଣ
ସାର୍ ଶୁଣନ୍ତୁ
ଜବରଦସ୍ତ ମୋ ଘରେ ରହିଛନ୍ତି ମୁଁ ବାହାରେ ଭଡା ରହୁଛି ତାପରେ ମେଣ୍ଟେନାନ୍ସ ଦଉଛନ୍ତି ଡବଲ ଯିବ ପଡି ମୁଁ ମେଣ୍ଟେନାନ୍ସ ବି ଦଉଛି
50,000 ହବ
ନାଇଁ ନାଇଁ 40,000 ମୁଁ 40,000
you are arguing against yourself.
ଜମା 40,000 50 ହବ କେମିତି
ଆପଣ
ମୁଁ 40,000 ମାତ୍ର ପାଉଛି
ଆଣିଛନ୍ତି ବର୍ତ୍ତମାନ ସେ ଦେଖିବେ ସେଟା ଡିସାଇଡ୍
ମାତ୍ର 40 ପାଉଛି
ଆପଣ ଯଦି ଆଗ୍ରି କରିଯିବେ
ଏଥର ତାଙ୍କ ପ୍ରେୟାର ହେଲା
ଟିକେ ଶୁଣିଲେ ଆମ କଥାଟା now if you agree for 10,000 I will persuade him ଯେ
10,000 ମୋ ଘର କିନ୍ତୁ ଛାଡି ଦିଅନ୍ତୁ ମୁଁ 10,000
ସିଏ ମତେ କଲେ ମାଜିଷ୍ଟ୍ରେଟ କଲେ 125
ମାଇ ଲର୍ଡ ଅଲରେଡି ଡିଭୋର୍ସ ସରିଯାଇଛି
ଏଭିକ୍ସନ ସୁଟ୍ ଫାଇଲ କରିବେ
ଡିଭୋର୍ସ ପରେ
ହାଇକୋର୍ଟ ର ଜୁରିସଡିକ୍ସନ ଆସିଯାଏ ଯେ ଟିଆରପିସି ରେ ଏଭିକ୍ସନ କରିଦବ ବୁଝିପାରୁଛନ୍ତି
ଘରେ ସେ ରହିବ
ଆପଣ ଯୋଉ ମାଇଲଟ କହିକି ମତେ ଏତେ ଉପରକୁ ଉଠାନ୍ତୁ
ଅଲରେଡି ଡାଇଭର୍ସ ସରିଗଲା ଆଲିମନି ହେଲା
ଭାଇନାହାନ୍ତି ଏକୁଟିଆ ରହୁଛନ୍ତି ଭଲ ରୁହନ୍ତୁ ସିଏ ରୁହନ୍ତୁ ନହେଲେ ଏଭିକ୍ସନ ସୁଟ୍ ଫାଇଲ କରନ୍ତୁ ସେଗୁଡା ଏଠି କଲେ କଣ 10,000 ଆଗ୍ରି କରି ମେମୋ ଦିଅନ୍ତୁ ସାର୍ ମେମୋ ଫାଇଲ କରିବେ ଭେରି ଗୁଡ ସାର୍ ସାର୍ ଦିସ୍ ଇଜ ମଚ୍ ବେଟର ଆପଣ ଯୋଉ ସବୁ କେସ୍ ଲଢୁଛନ୍ତି ସୁପ୍ରିମକୋର୍ଟ ଯାଏ ମେଣ୍ଟେନାନ୍ସ କେସ୍ ରଖିଛି ଆପଣ ମେନ୍ କେସ୍ ତ ସରିଲା କହୁଛନ୍ତି 10,000 ଆଗ୍ରି ଦେଇଦିଅ
ଆଜ୍ଞା ମୁଁ ଏମିତି ଦେଇଦଉଛି
500 ଆଉ ଛାଡିକି ପଳେଇବେନି ମୁଁ ବସିକି ରହିବି ଆପଣ ଯେତେ ବିଜି ଥିବେ ବସିକି ରହୁଛନ୍ତି ସାର୍
ସାଙ୍ଗେ ସାଙ୍ଗେ ଦେଇକି ଆପଣ
ମେମୋ ଦିଅନ୍ତୁ 10,000 Mr. Behra, you are saying that is home. ନହେଲେ you are very very difficult counsel. ନହେଲେ ଆପଣ 10,000 ରାଜି ହେବା ଲୋକ ନୁହଁ ଆରେ ଶୁଣିବା ପରେ ମୁଁ କହୁଛି I am not commenting. ଅଶୋକ ଛାଡିବା ଲୋକ ନୁହଁ
ଅଶୋକ ଛାଡି
ଜମା ଛାଡିବେ ନା
2 ଜଣ
ଆପଣ ତାଙ୍କ ଘରେ ରହୁଛନ୍ତି ସେଥିପାଇଁ 10,000 ଆପଣ and that's a good thing. At least you are settled for something.
ସେଟେଲ ମୁଁ ରାଜି ବଞ୍ଚି ଯାଆନ୍ତୁ ମାଇଲଟ ଠିକ ଆପଣଙ୍କ ଦୟାରେ
ନାଇଁ ନାଇଁ ସେଇଟା ଆପଣଙ୍କ ଦୟା ମୁଁ କିଛି କରୁନି
କ୍ରିମିନାଲ କେସ୍ କରିଥିଲେ ଦ୍ୟାଟ୍ ୱାଜ ଆକ୍ୟୁଟାଲ ହେଇସାରିଛି ସବୁ ହଜବେଣ୍ଡ ଫେଭରରେ ଏଭ୍ରିଥିଙ୍ଗ ଇଜ ଗୋଇଂ ଅନ୍ ମିଛ କେସ୍ କରିଥିଲେ ସେଥିରେ ମୁଁ
ଛାଡ଼ନ୍ତୁ ବର୍ତ୍ତମାନ ସାର୍ 10,000 ଟଙ୍କା ତାଙ୍କୁ ଥିଲା ତ ସେଟଲ ହେଇଗଲା ସରିଲା ମାନେ ରିଏଲି ଗୁଡ୍ ଫର ବୋଥ ଅଫ୍ ୟୁ ଗୁଡ୍ ଜେସ୍ଚର ଅନ୍ ପାର୍ଟ ଅଫ୍ ବୋଥ ଅଫ୍ ୟୁ ୟେସ୍ ନେକ୍ସଟ
16 ମାଇଲଟ
15 ପାସ୍ ଓଭର କହିଦେଲେ କୁହନ୍ତୁ ଆପଣ 15 ପାସ୍ ଓଭର 16
ମାଇଲଟ
yes
I am for the petitioner wife ମାଇଲଟ daughter ମାଇଲଟ unmarried daughter
you are Mr. Lenka
no man I am MR Das
Mr. MR Das for the petitioner
My lord, I am there in Vichy for the father, my lord. Myself, A.K. Utta, my lord.
So, it's not possible for you to mobile ଆପଣ ହବନି
My lord, I am thick enough, my lord. I am not able to move, my lord. I am compelled to appear before
colleague. Sir, please take rest. Take care of your health. The matter is urgent, but take care of request any of your colleague or your associate or anyone. They will help you.
obliged, my lord.
As per the petitioner, Mr. Arnanga Kumar Hutta, hybrid mode lecture. So Ananga Kumar Utta for the opposite party, learned counsel for the opposite party submits that appears in VC submits that he has personal difficulty. The matter is adjourned to be listed in the wing of HC. Kebe habo?
Sir, 30th को रखो sir.
No, man, no stay. There is a delay. They have to file the objection.
They are correct. 30 दिन कहउछन्ती.
Sir, my lord, 30th will be appropriate because I may take some time to be well enough.
Hey, apano, you better you take rest and request any of your colleagues to.
Lord, counter is to be filed.
30 दिन
have more.
Ela 30 दिन ଆସିବ ଆପଣ.
Obliged, man. Obliged. Much obliged.
Yes. Next, please.
In this case, notice has been gone to the opposite party, my lord. Till that, she has not appeared.
ଆପଣ ଚାହୁଁଛନ୍ତି କଣ କହିଲେ ଏଇଟା? What you want, sir? What you are challenging?
Challenging the expertise judgment, my lord.
What, sir? Regarding what?
Challenging the expertise judgment dated passed by the London Judge Family Court.
Maintenance ଦଉଛନ୍ତି ନା ନାହିଁ? Are you paying the maintenance? Secure the decree.
Yes, challenging the
deposit amount here if you do not want to pay.
No,
This in the garb of issuance of notice, the decree cannot be stayed. You have to secure deposit here. You take instruction.
yes.
That is contrary to the law laid down by the apex court. And this is a serious problem with maintenance cases. For years together, they are kept pending.
I take interest from it.
Your name, sir? Apoko naata?
Sushant Kumar Naik.
Sushant Kumar Naik for the petitioner, opposite party blank. Office note put up by the registry indicates that the notice issued to the opposite party. Wife in the marriage has been served personally. The petitioner in the the present revision application seeks to challenge the judgment passed by the London Judge Family Court dated 10/4/2024. Passed in Criminal Proceeding Number 71 of 2023. Under Section 125 of CRPC, into bracket, since repealed and substituted for a complete content. Bracket closed. Stop. The said application was filed by the wife in the marriage and a minor child represented coming under.
No child, man.
Wife in the marriage, seeking maintenance of rupees 30,000 per month and 5,000 towards separate accommodation. The total of rupees 35,000.
No, my lord. Page number 11, my lord.
Sir, पढ़िबे मु जदी पढ़ी मते डिस्टर्ब करिवे कोन नो माय लॉर्ड कहले कोन बुझिले कोन नो माय लॉर्ड कोथ पे कहउछन
अवार्ड हेछि 25,000 पर
कोन डाकि मु डाकि अवार्ड हेछि मु डाकिली आरंभ कली सेंटेंस the application was filed by the wife in the marriage seeking maintenance आपण कहले अवार्ड हेछि 35,000. The application was favored. However, एठी आपण कहया था आपण जो सुनथाते आपण स्ट्राइक करता था. The application was favored by the London Judge Family Court. However, granting a monthly maintenance of rupees 25,000 from the date of application, that is 15.03.2023 for our sustenance. So, the amount as directed to be paid is in the nature of a money decree. In view of the judgment rendered by the apex court in Rajneesh versus Neha, para 32/125, para of a CC brief. Bracket closed. On being asked whether the petitioner has secured the said decree or has paid any amount, ଏଇଟା ଆପଣ ନିହାତି ଶୁଣିବା କଥା। ଆପଣ କଣ ପଇସା ଦେଇଛନ୍ତି?
ନା।
କିଛି ଦେଇନାହାନ୍ତି। ସିକ୍ୟୁର କିଛି କରିବାକୁ ଚାହୁଁଛନ୍ତି? କରିପାରିବେ?
ସେଟଲମେଣ୍ଟ ପାଇଁ ଚାହୁଁଛୁ ତ
ସେଟଲମେଣ୍ଟ ପଇସା ମୁଁ କୋଉଠୁ ଆଣିକି ଦେବି? ସେଟଲମେଣ୍ଟ ଅନଲେସ୍ ଆଇ ପେ ଦ ମନି नो वन विल एग्री। ପଇସାରେ କଣ ସେଟଲମେଣ୍ଟ କରିବେ? ଆପଣ ଦେବେ? You will give. The order ହେଇଯିବ ଯେ the lawyer wants to pay the money and settle the amount. What is the concept of settlement in a decree of money for maintenance? Has paid any amount towards maintenance in any during the pendency of the proceeding or any other proceeding. The learned counsel for the petitioner upon instruction submits that he has not done so. Para no out para. On being asked whether the petitioner shall how the petitioner shall secure the amount which is in the nature of a money decree to challenge the same, the learned counsel for the petitioner submits he has no instruction. Para. पंदर तीन कोड़े तेईस रु पंदर तीन कोड़े 26 35 मास है ना। The amount of rupees 25,000 is dues for the last 35 months, that is from 15-23 to 15-2-26 है ना। The total amounting to rupees 35 गुणन 25,000 जहाँ हम लिखिदे। एग्जीक्यूशन फाइल हिची?
Yes.
स्टे हिची?
No. I'm
in view of the guidelines laid down by the Honorable Apex Court, larger bench in Rahul Shah, the execution petitions have to be para 41 has to be completed. Citation है इधर Rahul H. Shah versus so and so so and so. Janendra ना Janesh Janendra. But they लिखिए Rahul Shah, the execution proceedings have to be completed. Paragraph the petitioner should have secured the said amount before this court. Apparently, the EP number 237 of 2025 is kept pending due to filing and pendency of this petition. Though without securing the awarded amount stuff. It shall be the Lorded Court, the Lorded Executing Court shall proceed with the matter in the pending execution case. Copy of this order shall be forwarded to the Lorded Judge so and so so and so. Lorded Judge Family Court Berhampur to be kept on records of EP number 237 of 2025 arising out of CRP number 71 of 2023. The matter shall be listed in the week commencing. Kebe chanchoni sir?
1 month.
1 month. The week commencing 30 दिन ना kebe tapor na 6/4/2026. Sir, whenever you are receiving the brief, these questions you have to ask to the client. You are officer of the court. You have to have your effective role. This is not the way to scuttle the entire scheme of this maintenance. So this is respond karibani. Tanko choice. Sir.
My lord, with the excuse me, lord. I contact party, but she is not interested. 10,000 agree haba raji hore. Second, आपण if honorable court pass this order without agreeing, lordship में father but agree कर देले से
नहीं बहुत कहीं को दौड़िले सिटिले ना कौन
आगे
आपण को दौड़ुले कौन पे आगे किस तो मिलिबार नहीं कहीं दौड़ुले आपण
ना मु दौड़िले जस्टिस बीन
सेटा कहीं आपण तो सारू कोई की जाइतांते नहीं सेटा नहीं आई डायरेक्ट 10,000 ମୁଁ କଣ କହିବି କନସେଣ୍ଟ ଦେଇଥିଲେ ବୋଲି ନା ଆପଣ ଏମିତି ମେମୋ ଲେଖନ୍ତୁ ଯେ that the parties agree for the court to decide an amount reasonable amount ସେମିତି କରିଦିଅ
ସେ କାରଣ ପରମିଶନ ମିଳିଲା 12,000 ଟଙ୍କା ଆୱାର୍ଡ ହେଇଥିଲା ବର୍ତ୍ତମାନ 49,000 ପାଉଛନ୍ତି ମୁଁ ରିସିପ୍ଟ ଫାଇଲ କରିଛି
ସେଇଟା ସାର୍ ଆପଣ 12,000 ଟଙ୍କା କୋଉଥିରେ ଆୱାର୍ଡ ହେଇଥିଲା ଆପଣ ତ କହିଲେନି ସେତେବେଳେ
ଫ୍ୟାମିଲି କୋର୍ଟ ଆୱାର୍ଡ ହେଇଥିଲା
ସେକ୍ସନରେ ସାର୍
21-25
125 ରେ ସୋ ଏନହାନ୍ସମେଣ୍ଟ ଟା କୋଉଥିରେ ହୁଏ
ନା ମୁଁ ଏନହାନ୍ସ ଚାହୁଁନି
ତାହେଲେ ଆପଣ ସେଟା ଫାଇଲ କରିବେ ନା
ମୁଁ ଓନ୍ଲି ଫାଇଲ କରିଛି
12,000 ଟା ଯେହେତୁ ତାଙ୍କର ସାଲାରୀ ବଢିଗଲାଣି 125 ଟୁ ଫାଇଲ କରିବେ ସେଟା ସାର୍ ଅପୋଜ କରିବେ ସେଠି ଯିଏ ଅପୋଜ କରିବେ
ସେ ଗୋଟେ ଦିଅନ୍ତୁ ମୁଁ ତ ଫାଇଲ କରିଛି ଷ୍ଟେଟା ଉଠିଯାଉ ନା ମୁଁ ଏଠି ଷ୍ଟେ ପାଇଁ
ଦିଅନ୍ତୁ କଣ କୋଉଠି ଦେବେ ଆପଣ ସବୁ ଯାକ କେସ୍ ଏକାଠି କଲେ ହବ କି ଏଠି
ନା ମୁଁ ସେଟା କହୁନି ମିଲା
ଏଠି ଯାଆନ୍ତୁ କେସ୍ କରନ୍ତୁ
ନା ମୋ
ପିଲାକୁ ଛାଡି ଦିଅନ୍ତୁ ସେ କିଛି ଫିସ୍
ନା ମୋ କହିବା କଥା ମାଇଲର ଏଇ ଯୋଉ ଷ୍ଟେ ଅର୍ଡର ଥିଲା ଷ୍ଟେ ଅର୍ଡର ଭାକେଟ করে ମୁଁ ଆସିଛି ଆଉ କିଛି
I understand sir but I
25,000 ପୁଣି ଦିଆଯାଉ
ଅଲଟରନେଟିଭ ପ୍ରେୟାର କରୁନାହିଁ
Mr. Das, it is in your interest. ଆପଣ ଯଦି ସିରିୟସଲି ଚାହୁଁଛନ୍ତି ଏନହାନ୍ସମେଣ୍ଟ ପର୍ସୁ ଦ ରେମେଡି ଡୋଣ୍ଟ କିପ୍ ଦିସ୍ ମ୍ୟାଟର ପେଣ୍ଡିଂ ଆପଣଙ୍କର ଯେତେ ଦିନ RPFM ଏଠି ପେଣ୍ଡିଂ ରହିବ ଗୋଟେ ଟଙ୍କା ବି ଏନହାନ୍ସ ହେଇପାରିବନି କହିବେ ଆଜ୍ଞା ଏଠି ପେଣ୍ଡିଂ ଅଛି ଆପଣ କଣ ସାର୍ ଏ ଆଡଭାଇସ୍ ଇଜ ରେଣ୍ଡର୍ଡ ଟୁ ୟୁ ଫ୍ରି ୱିଥ୍ ଅ ପର୍ପସ୍ at least you are not stuck in this matter you agree for a settlement in the sense कि 10,000 ରେ ଆପଣ ତ କିଛି କମ ପାଉନାହାନ୍ତି ଯଦି ଏନହାନ୍ସମେଣ୍ଟ ଚାହୁଁଛନ୍ତି ଫାଇଲ କରନ୍ତୁ
ଏନହାନ୍ସମେଣ୍ଟ ଚାହୁଁନି ମୁଁ ଖାଲି ଚାହୁଁ ଷ୍ଟେ ଅର୍ଡର ଭାକେଟ ହେଇଯାଉ
ତାହେଲେ ଏଟା ହିୟରିଂ ହବ ଛାଡିଦିଅନ୍ତୁ
ମୁଁ ଅବଜେକ୍ସନ ଦେବି ତାହେଲେ
ଠିକ ଅଛି ଆପଣଙ୍କର ଏଇ ଯୋଉ ଜିନିଷଟା ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ବୁଝିପାରିବେନି କିନ୍ତୁ ଆପଣ ବୁଝିପାରିବେ
ମୁଁ ବୁଝିପାରୁଛି ମତେ
ଆପଣ ଯଦି 20,000 ଚାହୁଁଛନ୍ତି ଆପଣ ତ କହିଲେ କି ଆଜ୍ଞା ଆପଣ ଯଦି 20,000 ଟଙ୍କା କ୍ଲେମ କରିବେ ତାହେଲେ ସେଟା 125 ରେ 2 ରେ ଫାଇଲ କରିବାକୁ ପଡିବ
ନା
125 2 ରେ ଯଦି ସେ ରିଜେକ୍ଟ ହେଇଗଲା ତାହେଲେ ଆସିବେ
ନା ସେଇଟା ମୁଁ
ସିଏ କରନ୍ତୁ 125 2 ରେ 12,000 ଟା 15,000 ହେଇଗଲା ସିଏ ଆସିପାରନ୍ତୁ
ନା ଆମର
ଆପଣ ଯୋଉ ଏଇଥିରେ ଅଟକିକି ରହିଲେ ବର୍ତ୍ତମାନ ଇଟ କ୍ୟାନଟ ବି ଏନହାନ୍ସଡ
ନାଇଁ ନା ସେ ସେ ପାଟା ମାଇଲଟା ବିଗିନିଂ ଟେଲିଂ ଆସୁନାହିଁ ପୁଣି ଲକ୍ଷ୍ୟ
ଶୁଣନ୍ତୁ ଆପଣ
ଆମ ରେକର୍ଡିଂ କନସେସନ ନ କରିକି ଆପଣ କରିଦିଅନ୍ତୁ
ସେଇଟା ଆଜ୍ଞା ମୁଁ ତ କହୁଛି ଯେ ଆପଣଙ୍କର I will say that you do not agree that he doesn't agree to beyond 7,000 but as a justice equity good conscience 10,000
সেটা আছে
dispose of at least you have an opportunity to
I agree
ঠিক আছে এটা କେତେ নম্বର ଆଇଟମ ଆପଣଙ୍କ
ଆମ 15
I will dictate the order
ମାଇଲର
10 ଯଦି କରିବେ
ସନତ କୁମାର ଦାସ ମିଷ୍ଟର
ଅଶୋକ ଦାସ
ସାର୍ 11 କରିଦିଅନ୍ତୁ
10 ଠିକ ରହୁ ଘରଟେ ରହୁଛନ୍ତି ସାର୍ ମୁଁ ଆପଣ ତାକୁ ତ ମୁଁ ମତେ ବୁଝିବା
ପିଲାଟା ମାଇଲର
ମୋ ଘରେ ରହୁଛନ୍ତି ସେମାନେ
ଏଦିନ ତାର ଷ୍ଟେ ନେଲେନି 500 ଆପଣ 10,000 ଯୋଉ ଦିନଠୁ ଅର୍ଡର ହେଇଛି ସେଇ ଦିନଠୁ ଦେବେ
10,000 ଦେବେ ଆପଣ
ପର୍ସପେକ୍ଟିଭ ହବନି
ଯାହା କହିବେ
ଠିକ ଅଛି ତାହେଲେ ବିଷୟ ଦାସ ଭାବେ ଗୁଡ
ଆଜ୍ଞା 10,000 ହେଲେ
ସେ ଦେବେ ସେ କୋଉଦିନ ପୁରାଟା ଦେବେ 10,000 You can wait, I will dictate the order ଯଦି ଚାହିଁବେ ନହେଲେ I will dictate the order after recess ଆପଣଙ୍କ ଚଏସ୍
ଆପଣଙ୍କ ଚଏସ୍ ମିଳିଲା ଆମ ଚଏସ୍
ନାଇଁ ସାର୍ 10,000 ଟା ସେ I hope you understand what I am saying 10,000 ଟା from the date of initial date ରୁ 12,000 ଟା 10,000 ସେ 7,000 ଯଦି ଦିନ ଦେଇନାହାନ୍ତି 3,000 ଦେବେ
ଆଉ 3,000 କେତେ ମୁଁ ଦେବେ
କହିଲେ ଆପଣ ସାମ୍ନା ସେଇ ଜିନିଷଟା
6-4 କରି କରିବେ ୱାଇଫ ଆଉ
ଯାହା ଲେଖା ହେଇଥିବ ମୁଁ ଆଇ ମଡିଫାଇ ଯାହା ଯୋଉ ମୁଁ ଦେଖିବି ତ ପାସ୍ ଅର୍ଡର
10 କରନ୍ତୁ ଡେଟ୍ ଅଫ ଆପ୍ଲିକେସନ
11 ଗୋଟେ ଦିନ ତ ମାଇଲର କହିଲେ
ନାଇଁ
ନାଇଁ ଆପଣ ତାଙ୍କ ଘରେ ରହୁଛନ୍ତି ନହେଲେ ଆପଣ ଜମା ଛାଡିବା ଲୋକ ନୁହଁ
ସେ ବି ରହୁନାହାନ୍ତି
ସେ ଜାଗା ଭଡା ନେଇକି ରହୁଛନ୍ତି ଭଡା ଦେଇକି ରହୁଛନ୍ତି ମାଇଲର ସେ କହୁଛନ୍ତି ଭଡା ନେଇକି
What I beg to submit, my lord, because matter is very urgent. I filed.
You have to move.
No,
move for listing before the registry.
No, registry. They said that I also had been to his lordship's chamber, and I said that registry cannot list unless they.
I cannot allow memo.
No, your lordship may say that it may be before the assigned bench. So, because urgency is that. I'm just.
You have to read this.
I
will pass over your mention. You read this.
No, urgent matter listed today will be taken up.
No, can you read that? Then today morning only I was reading that judgment that the determination of the Chief Justice of a court is the determination by the roster.
Except tied up matter.
No, can you read the entire thing?
Yes. As directed by the
The assignments of the Honorable the Justice Rathod shall be moved before the, so that letter you are adding, those sentences.
exceptionally urgent matter assigned to the single bench of Honorable Miss Justice Savitra Rathod may be moved before the.
So moving is what is in the list.
Hello?
You are asking for listing of the matter.
No. I just heard that that bench may not function also tomorrow because this is she may sit.
So tomorrow there will be another assignment. Tomorrow we will
what today your lordship just
you are partly correct. You wait for tomorrow.
I think my matter will be infructuous.
Could be.
But
you see, as far as out of turn listing, special notice.
No, I'm not saying that matter to be taken up today. I'm just making a mention that your lordship may send my memo to the registry to be listed.
You move the registry the way the other court takes up the matter. Like I take up the matter, so I cannot take up the other matter. The same thing.
But in that case, my matter will be infructuous.
No, I have not made it infructuous.
No. You have also need to because the situation.
You are saying as if I have made
no. Situation will make my matter infructuous.
Sir, as far as listing is concerned, you should have moved your matter before the bench. Yesterday or day before yesterday.
The bench is not there.
So today, if you want to move the matter, you have to, because the bench is otherwise available. You must understand. And the honorable judge is presiding judge is available.
Presiding judge,
so they registry will do
the chamber, and I told
chamber. I do not entertain any. I cannot tell about that.
I told that she said that it cannot be. I cannot take up because today I don't have the court, so I cannot allow your memo. So you may move the in charge court for mention. So if you mention
that consultation I cannot take with the
no, I'm not telling lie.
No, you should not.
All matter are going serially before the assigned. All matter are going serially before the assigned court. So
I cannot break that.
No. All matter are going serially. But if it is an urgent matter, exceptional urgent, you have to make a mention. The register
so my assignment is only the matters
taken up the matter which are in the list.
Correct.
But my lord, but tomorrow will be the same thing will happen.
Then you understand. You are too much experienced to know.
I know, my lord.
So obviously, who is to be moved then? For assignment of any matter, there is only one court, the first court. No other court can do that. Let us assume I am impressed with you. I like you. I passed that order. And that list Mr. Acharya's matter. So I cannot do that. Then why does this matter?
Now my
Tripathi mentioned one matter also.
No.
I didn't realize that matter is not in the list. I said that before writing or before doing also. He did not inform me.
2 days after
it has happened. No, it has already happened. Perhaps you are not realizing. Already some matter which was mentioned, I thought in the list. I said I'll take up. He has listed the matter. He didn't also understand what I said.
If the matter which are in the list, is the notice.
Sir, item 29, both of us are there.
Yes, please.
I'm not very well.
Take a date, 29.
It
is convenient. I am also any day because argument is over. The 3 notes have been submitted. It is for judgment.
Before this bench or
nine.
So then it has to be heard again. Date करो तो 29 that.
We commencing 30 दिन.
We commencing 30 दिन.
30 दिन.
Yes. So in that week the matters are distributed. So little bit, instead of a specific date, it becomes easier to distribute in the week.
Sir, ये जो matter टा mention करते आचार्य जो, हमें तो जा जाने तो assigned bench माने your lordship could take it up for put up.
But I do not take out of turn. मुझे जो अन्य assignment out of turn ने भी आज special mention.
Sir, सेत्रे मुको.
23 February.
ना.
3 March.
आज उसमें 23, आज 24. से एपट सपोर्ट है बहुत से भूल होची मुझे डाकिला बड़े बहुत डेट भूल है साल तो योटा Ankara Passover
item 15.
Mr. Sanat Kumar Das for the petitioner. Mr. Ashok Das for the opposite party. The learned counsel for the parties were heard at length. দুটা স্পেশাল নোটিশটা ଆପଣ ଡାକି ନାହାନ୍ତି ସ୍ପେଶାଲ ନୋଟିସ୍ ମେଟରଟା ଦିଅନ୍ତୁ ଆପଣ ଏବେ ଆପଣ ନେଇଯାନ୍ତୁ ଏଇଟା ଆପଣ ଏଇଟା ନେଇଯାନ୍ତୁ ସ୍ପେଶାଲ ନୋଟିସ୍ the matter was mentioned by the senior advocate for the petitioner फाइलଟା पड़े गला फाइल को स्कैन कर देले
नहीं सर फाइलटा आसनी
फाइल ही आसे
ना
तो लिस्ट पे है ଆପଣ ଜାଣିଲେ କେମିତି ତାହେଲେ ଫାଇଲଟା ଆସିନି କୋଉ ଫାଇଲଟା ଦେଲେ ନମ୍ବରଟା କେମିତି ଜାଣିଲେ
सर से नंबरটা
ଚେକ୍ କର ଚେକ୍ କର लिखलेली किसी लिखना है हाँ हाँ the petitioner in the petitioner in the petition is the husband in the marriage seeking revision of the order revision of the judgment dated 12/7/2023 passed in CR.P number -291/2023. Stop. The judgment has been passed by the learned judge Family Court Jajpur in criminal proceeding number 291/2021. The said proceeding was initiated by the opposite party number one wife in the marriage and the minor daughter born from the wedlock seeking monthly maintenance under section 125 of the CRPC into bracket since repealed bracket closed. So the by the judgment, the prayer of the the wife in the marriage and the minor child were allowed and an amount of rupees 5,000, 7,000 per month to the petitioner number one and 5,000 per month to the petitioner number two child was awarded from the date of application, that is 21.12.2021. By order dated 14/9/2023, notices were issued by the coordinate bench. In the interim, directing payment of current maintenance at the rate of rupees 4,000 to the opposite party number one wife and 3,000 to the opposite party number two minor daughter. While issuing notice, While issuing notice and granting interim order directing payment of interim maintenance, the collegiate bench had directed stay of operation of the into judgment dated 12/7/2023. For arriving at the conclusions, the learned family judge has relied on the statements of the petitioner, no statement of three witnesses on behalf of the opposite party, who were the petitioner, opposite party wife, who was the petitioner, and one witness on behalf of the opposite party before the learned judge family court, who is the petitioner here. The learned judge family court has relied on the exhibits, relied on 5 exhibits produced by the petitioner wife and 4 exhibits, those were exhibited on behalf of the opposite party husband, petitioner hearing. Exhibit P1 was the salary statement of the is the exhibit P1 is the salary statement of the husband in the marriage obtained through the RTI Act. The scope of interference paragraph, the scope of interference by this court in exercising the revisional jurisdiction has been dealt with by the Honorable Supreme Court in Samima Faruqi. Art paragraph 21 of Samima Faruqi. The list number. Para 20 of Samima Faruqi. The scope of interference by this court has been delineated. Having heard the learned counsel for the petitioner and going through the materials on record, particularly the reasons given by the learned judge family court, at paragraph 7, 8, and 9 of the judgment, It has to be held there. There is no error in the judgment rendered. The judgment is based on proper appreciation of evidence on record and substantial justice has been done. As a residuary submission, it is submitted by the learned counsel for the opposite party.
Wife.
Wait. As a residuary submission, it is submitted by the as an alternative submission, it is submitted by the learned counsel for the petitioner, husband with the marriage, that the opposite party wife and child are staying in the residential premises of the petitioner husband, for which some indulgence may be shown as far as amount directed by the learned judge family court to be paid. The learned counsel for the opposite party, though does not seriously challenge the said aspect of the mother and child staying in the residential premises of the petitioner, objects to the prayer for any reduction of the amount of maintenance directed by the learned judge family court. So, however, in the interest of justice and equity, it is directed that however, in the interest of justice and equity, without interfering in the conclusion of the learned judge family court in directing maintenance, like a monthly maintenance, the order is modified to the limited extent that the petitioner shall pay rupees 6,000 per month to the petitioner to the opposite party number 1 wife and rupees 4,000 per month to the minor daughter opposite party number 2 from the date of application, that is 21.12.2021. From the amount that is due to be paid with effect from 21/12/2021. The amount that has already been paid shall be deducted to determine the amount due. The petitioner shall credit the amount directly to the bank account if it is available. Bank account of the petitioner number 1. So literally, the petitioners shall directly credit the amount. Credit the amounts to them. Credit the amount or credit the amount to be paid to both the OP number 1 and 2. OP number 2 being a minor, directly to the account of the bank account of the OP number 1. The judgment and decree is affirmed with the aforesaid modification. The petition is disposed of. Yes.
My lord, permission, my lord. One liberty may be given by the wife to file enhancement petition with the
But that liberty is not necessary.
Otherwise, it will
Once you fall into that method, you never know what they will argue. Sir, when you file an enhancement petition, let them argue that there is no liberty granted.
Always
You must understand, you should never, you should be careful in bringing something upon you which is not necessary. Because that may create complication for you.
Otherwise, my lord, it will be impact by that you will not file because Hon'Ble High Court fix the amount, that is the 10,000. You will debar from filing the.
Let the court become so erudite and
if so,
জ্ঞানী ବିଦ୍ୱାନଙ୍କ ଅଭାବ ନାହିଁ ସେଥିରେ ଆମେ କଣ କରିପାରିବୁ ଆପଣ ସେ ଅଛନ୍ତି ଯଦି ଏଇଟା କୁହାହେଲେ ଯେ ଭବିଷ୍ୟତରେ ଏନହାନ୍ସ ହେଇପାରିବନି କି ଫାଇଲ କରିପାରିବେନି
ଏଇଟା ହବ
ତାହେଲେ ମୁଁ ଡେଟ୍ ଟା କାହିଁ କହିଲି କାରଣ ସେ ଡିକ୍ରି ଆଉ ଜଜମେଣ୍ଟ ଇଣ୍ଟରଫିୟର କାହିଁ କଲିନି
ସେ ବୁଝିପାରିବେନି ଆଜ୍ଞା ଆପଣଙ୍କର ସେ ଖାଲି ଆପଣ ଖାଲି ଗୋଟେ ଖାଲି କୁହନ୍ତୁ ଇଟ୍ ଇଜ ନଟ୍ ଇମ୍ପୋର୍ଟାଣ୍ଟ ମାନେ नो इफ सो एडवाइस
ସେଇଟା ଆଜ୍ଞା ମୁଁ ଆପଣଙ୍କୁ କହିଲି ବୋଲି ଆପଣ ବି ଏଇଟା କହୁନଥିଲେ because I discussed with you ଆପଣ ଭାବିଲେ ଯେ ସେଇଟା I cannot curtail also
curtail ହେଇଯିବ କାରଣ Hon'Ble High Court 10,000
ସେମିତି କୋଉଠୁ ନାହିଁ ସେମିତି ପ୍ରୋଭିଜନ ନାହିଁ ଯେ ଗୋଟେ ଜଣଙ୍କର ରାଇଟ୍ ଟାକୁ ମୁଁ curtail କରିଦେବି
ସେ ତ ସେଇଟା ପ୍ଲି ନେବେ ନା Hon'Ble High Court 10,000 କଲେ ଆପଣ ଏନହାନ୍ସ କରିପାରିବେ ନାହିଁ ସେ ପ୍ଲି ନେବେ ଆଜ୍ଞା ଆପଣ ଖାଲି ଏଇ ସେ ଲାଇନଟା ବୁଝିଲେ
ଆପଣ ଆଜ୍ଞା ଏଗେନ୍ କାଇଣ୍ଡଲି ମିଷ୍ଟର ଦାସ ଭାବନ୍ତୁ କଣ କହୁଛନ୍ତି ଗୋଟେ ଡିକ୍ରି ଆଉ ଜଜମେଣ୍ଟ ହେଲା ଡିକ୍ରି ନେଚର ଅଫ ମନି ଡିକ୍ରି ଆୱାର୍ଡ ହେଲା ସେଟା ଚ୍ୟାଲେଞ୍ଜ ହେଲା ସେଟା ଚ୍ୟାଲେଞ୍ଜରେ ସେଟା କନଫର୍ମ ହେଇଗଲା ଆଉ ଭବିଷ୍ୟତରେ ସେଟା ଏନହାନ୍ସ ହେଇପାରିବନି
ସେଟା ପ୍ଲି ନେବେ ସେମାନେ
ସେଟା ଦେଖନ୍ତୁ
ଏଇଟା କେତେ ପିଜୁଡି ସବାନି ତାଙ୍କୁ ନା ଅପୋଜିଟ ପାର୍ଟି ପିଜୁଡି ହବ କି ଆପଣ ଯୋଉ ଲିବର୍ଟି ଦେବେ
ଆପଣଙ୍କର ଯେତେ ଇଆଡୁ ସିଆଡୁ ଅର୍ଡର ହୁଏ ସେଥିରେ ଆପଣ
ଗୋଟେ ଖାଲି
ଆଜ୍ଞା ଯଦି ଲାଷ୍ଟ ଏଇଟା ଯଦି ଲାଷ୍ଟ ଆଜି ଅର୍ଡର କରିଥାନ୍ତେ ତାହେଲେ କୋର୍ଟ ଚାଲନ୍ତାନି ଚାଲିବ ଆଜ୍ଞା ଆପଣ
ଖାଲି ଗୋଟେ ଲାଇନ ଖାଲି if so advice
ସେଥିରେ ବସିବାର ଅଛି ଆଜ୍ଞା I am not dealing with 125 aspect I am not at all dealing with 125
ଆମେ ପ୍ରେୟାର ତ କରିବୁ ମାଇଲଣ
125 ମୋର କ୍ଷମତା ନାହିଁ ଆଜ୍ଞା ମୁଁ ଆପଣଙ୍କୁ କହିଲି ସେଟା ଆପଣ ଯଦି so in fact it is my initiative that you realized that keeping the matter pending here doesn't help you if you want any enhancement ଆପଣ ଧରନ୍ତୁ during pending source you can file an enhancement ନା ନାହିଁ
ପେଣ୍ଡେନ୍ସ ଥିଲା
ଏକ୍ସାକ୍ଟଲି ଆପଣ ଯଦି ଏଇଟା ସେତେବେଳେ ରାଜି ହେଇଥାନ୍ତେ ତାହେଲେ ହୁଏତ ଏନହାନ୍ସମେଣ୍ଟ ଫାଇଲ କରିପାରିଥାନ୍ତେ ଆପଣ ଲିବର୍ଟି ନେଲେନି ଯେତେବେଳେ ନୋଟିସ ଇସ୍ୟୁ ହେଲା ଆପିୟର କଲା ପରେ
ନା ସେଟା ଷ୍ଟେ ଅର୍ଡର ଥିଲା ବୋଲି ଆମେ କିଛି
ତାପରେ ଶୁଣନ୍ତୁ ଓବିୟସଲି ଦେ ହାଭ୍ ଅଲସୋ ସାକ୍ରିଫାଇସ୍ ତାଙ୍କର 7,000 10,000 ହେଇଛି ସେଟା କାହିଁ ଭାବୁନାହାନ୍ତି
ହେଇତ ମତେ ଖାଲି ଏଟା ତ କିଛି ହବନି ଖାଲି ଜଷ୍ଟ ଗୋଟେ ଖାଲି ଆମେ ଲିବର୍ଟି ନେଲୁ ଆମେ ଇଫ୍ ସୋ ଆଡଭାଇସ୍ ପିଟିସନ
ଲିବର୍ଟି ପାଇଁ କୌଣସି ଲିଗାଲ ପ୍ରୋଭିଜନ ପାଇଁ ଆପଣ ଲିବର୍ଟି ନେବା ଦରକାର ନାହିଁ ମୁଁ କାହିଁ ସେଥିରେ
ବେଳେବେଳେ ଏଟା ଆମର ପ୍ରୋବ୍ଲେମ ହବ ଯେ Hon'Ble High Court
ଆପଣଙ୍କୁ ପ୍ରୋବ୍ଲେମ ଲାଗୁଛି ମୁଁ ଆଜ୍ଞା 125 ପୁରା ଅର୍ଡର କରିବି ଆପଣ ଅର୍ଡର
ନା ମୁଁ କଣ କହିଛି ଭାଇ
ତାହେଲେ ଆରେ ଆପଣ ମାନେ ଆପଣ କହୁଛନ୍ତି ଜଜ୍ କହିବେ
ନା ମୁଁ ସେ କଥା
ଜୁର କହିବେ
ଖାଲି ଗୋଟେ ପ୍ରେୟାର ଥାଉ ଇଫ୍ ସୋ ଆଡଭାଇସ୍ ନଟ୍ ଲିବର୍ଟି ସେ ମେ ଫାଇଲ ଏନହାନ୍ସମେଣ୍ଟ
ଆଜ୍ଞା ମୁଁ ଆଇ ଆମ୍ ଡିଲିଂ ଓନ୍ଲି ରିଭିଜନାଲ ଜୁରିସଡିକ୍ସନ ଆପଣ ଯଦି ରିଭିଜନାଲ ଜୁରିସଡିକ୍ସନ ପଢିବେ ସେ ଯୋଉ ସେମିନାର ଥରୁକି ଏଇ ସବୁ ଜିନିଷ ଯୋଉଟା ଆପଣ କହୁଛନ୍ତି ମୁଁ ଲେଖିଲେ ବହୁତ ହେଇଯିବ
interim order ଟା ଭାକେଟ ଖାଲି ଏମିତି ୱାର୍ଡ
the interim order passed earlier shall merge with the final order ସେଟା ତ ମଡିଫାଇଡ ହେଇଗଲାଣି
ଆଉ ତାର ଫ୍ୟାମିଲି କୋର୍ଟ ଖାଲି ଡାଇରେକ୍ଟ ଆପଣ କହିଲେ ଯୋଉ ଡାଇରେକ୍ଟଲି ଦବ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏମ୍ପ୍ଲୟ ନା ତା ସାଲାରୀ ଆଟାଚମେଣ୍ଟ
ସେଟା ଆପଣ ମୁଭ୍ କରିବା କଥା ଆପଣ ମୁଭ୍ କରିନା
ଖାଲି ଗୋଟେ ଲାଇନ କରିଦେବ ମୁଁ କରିଦେବି ସବୁ ଯାକ ସ୍ତ୍ରୀ ଲୋକ
ସ୍ତ୍ରୀ ଲୋକ ଆଜ୍ଞା ଆପଣ ସ୍ତ୍ରୀ ଲୋକ ପାଇଁ ଫ୍ୟାମିଲି କୋର୍ଟ ଅଛି ମୁଁ କଣ ଫ୍ୟାମିଲି ଅଛି ଆପଣ ଯଦି ସେ ପଇସା ଦେବେନି ଏକ୍ଜିକ୍ୟୁସନ କରିବେ ସେସବୁ ଜିନିଷ ଅଲଗା କଥା ଯଦି ଦଉଛନ୍ତି ସେ ଦେଇଦେବେ ଆଉ କଣ
ଖାଲି ଗୋଟେ ଲାଇନ କରିଦେଇଥିଲେ ଯେ ଫ୍ୟାମିଲି କୋର୍ଟ ଡାଇରେକ୍ଟେଡ ଟୁ ତା ସାଲାରୀ ଟାକୁ ମନ୍ଥଲି ଦବ
for enforcement of the decree the petitioner the opposite party shall have liberty to have appropriate remedy available under law if the amount is not paid ଏଇ ଯୋଉ ଜିନିଷଟା ଆପଣ ଏଇଟା ଆଭଏଡ ମୁଁ କାହିଁ ଭାବିବି ଯେ ସେ ଦେବେନି ବୋଲି ମୁଁ ତ ଡାଇରେକ୍ସନ ଦଉଛି ସେ ଦେବେ ବୋଲି
Yes, please. Here I have challenged the judgment passed by the Judge Family Court Bhubaneswari Lordship.
Yes.
Under section 125 of the
Mr.
CRPC.
Subhash Chandra Pushpalaka for the petitioner. Yes.
Here, Millers, there is a delay.
Opposite party black.
There is a delay, Millers.
Sir, what is the award? What is the amount due?
Millers.
That is the main question. Delay or other delay makes no difference.
Millers. Your Lordship can glance to
how much is due? How much he has paid?
5,000 to son Millers and 3,000 to wife, Your Lordship.
8,000.
From the date of application, Millers.
So, how much is due?
Millers, that I have not calculated, Millers.
So, you calculate and comment.
Millers, from date of application, the application date, Millers, is a...
There is a keto dismissed. ତାହେଲେ dismissal ହବ ଆଜି ହବ ଯଦି ଆପଣ secure କରିବେ entire amount ଏଠି ଦିଅନ୍ତୁ I will issue notice।
ଏଣ୍ଟାଟା ଦେଇପାରିବେନି ମୁଁ କିଛି ଡିପୋଜିଟ୍ କିନ୍ତୁ
କିଛି ହବନି ମୁଁ ତ ଏଇଟା ବାଣ୍ଟୁଛି କି ମୋ choice ରେ you see the law has evolved like that maintenance should not be ଆପଣ ତାହେଲେ ହାରିଗଲେ କାହିଁକି ଆପଣ ସେଠି ତାହେଲେ ଆପଣ ତ ହାରିଯାଇଛନ୍ତି ନା there is a duty against you।
ମୋର ଥିଲା ମୋ ଯୋଉ ମଦନ ମୋହନ ଶତପଥୀର ଯୋଉ ଜଜମେଣ୍ଟଟା ହେଇଛି ସେ ମୋଠୁ ହାଇଲି କ୍ୱାଲିଫାଏଡ ସେ ସର୍ଭିଂ ଇନ୍ ଏ ପ୍ରାଇଭେଟ
ସେଟା ଆପଣ Justice versus Nehar exactly deal ହେଇଛି ସେଟା capacity to earn a wife ଆପଣ sir I have seen you at the bar you are not that naive I know the kind of preparation you make
smooth dispute
if I start writing that that's completely illegal if I start following Madan Mohan Satpathy highly qualified capability of earning
ତାପରେ ସୁପ୍ରିମକୋର୍ଟ ଜଜମେଣ୍ଟ ବି ଆସିଲାଣି ତାର ଇନକମ୍ ଥିଲେ ମଧ୍ୟ ଆମେ ଦବା ପାଇଁ
no it is very clear it's very clear actually and not difficult to understand and not difficult to understand also what Supreme Court has said if you read anyone can understand what the Supreme Court has laid down and that is the principle in fact it is nothing new but because of this I mean the strategy of not paying anything
she has filed the execution case that
is
pending
is true you must understand that Supreme Court has issued guideline and directed the High Court to formulate and circulate that no execution should be kept pending
I'm ready to
and you have to
entire amount of at a time ଦେଇପାରିବେ
instruction ନିଅନ୍ତୁ ସେ ଆପଣ ସାଙ୍ଗରେ bargain କରିବେ ନା
ମୁଁ
the problem is that the client comes to you and he starts bargaining ଆଜ୍ଞା ମୁଁ ସେ 10 ଟଙ୍କା ଦେଇଥିଲେ ମୁଁ ଟଙ୍କାଟେ ଦେବି ଆଜ୍ଞା ସେ this is not a marketplace for bargaining of decrees ଗୋଟେ judgment and decree Business versus Neha says it's a money decree it says section 51 all civil detention the attachment of property ଆଉ ଏଠି ସେ ଆସି ଆପଣଙ୍କ ସାଙ୍ଗରେ bargain କରିବେ ଆପଣ ଯଦି ତାଙ୍କୁ ରଜନୀଶ ବର୍ସେସ ନେହାରେ ଦେଖିବେ ଯେ ଆପଣଙ୍କ ପ୍ରପର୍ଟି ଆଟାଚ ହେଇଯିବ ସାଇଲେଣ୍ଟ ଚାକିରି ଚାଲିଯିବ ସେ ଠିକ ଅଛି ଆଉ ଜଣଙ୍କ ପାଖକୁ ପଳେଇବେ but that should stop
ଚାକିରି ସେ କରୁନି ଲେବର କ୍ଲାସ
ସେ ଲେବର ସେଇଟା ବି ଡିଲ୍ ହେଇଛି ଆକ୍ଚୁଆଲି
ଆଜ୍ଞା
ସେଇଟା ବି ରଜନୀଶ ବର୍ସେସ ସେ ଲେବର କ୍ଲାସ ସେଠି ପ୍ରୁଭ୍ କରିଥାନ୍ତେ ତାଙ୍କ ଅର୍ନିଂ ପ୍ରୁଭ୍ କରିଥାନ୍ତେ ନା ଆଉ ସେ ତ ହାରିଗଲେ କେସଟାରେ ହାରିଗଲା ପରେ ସମସ୍ତଙ୍କର when I started reading law this was introduced that when you marry you are a prince when you depart you are a pauper
ମୋର ପିଟିସନ ରିଭିଜନ ପିଟିସନ ମତେ ମୁଁ ସେ ଷ୍ଟାର୍ଟ ନେଇଛି ଦ୍ୟାଟ ଆସ୍ପେକ୍ଟ ହ୍ୟାଜ ନଟ୍ ବିନ୍ କନସିଡର୍ଡ ବାଇ ଦ ଜଜ୍ ଫ୍ୟାମିଲି
ଆସ୍ପେକ୍ଟ କୋଣ ହୁଏ ଦ୍ୟାଟ ରିଟ୍ ପିଟିସନ ଆପଣ ଲେବର କ୍ଲାସ ଆପଣଙ୍କ ଇନକମ୍ ଆପଣ ପ୍ରୁଭ୍ କରିଥିଲେ ଆପଣ ଯାହା ପାଖରେ ଖଟୁଛନ୍ତି ଧରନ୍ତୁ ସେ ଆପଣଙ୍କର ଘରେ କାମ କରୁଛି ଆପଣ ଦେଇଥାନ୍ତା ସୁଭାଷ ପୁଷ୍ପରାଜ ତାକୁ ଡେଲି ମଜୁରୀ ମାସକୁ 3,000 ଟଙ୍କାରେ ଡେଲି ମଜୁରୀ ରଖିଛନ୍ତି
ମୁଁ ଇନଷ୍ଟ୍ରକ୍ସନ ତାହେଲେ ନଉଛି କେତେ ଡିପୋଜିଟ୍ କରିବ କେତେ ଦିନ ଭିତରେ ଲର୍ଡସିପ ଆର୍ଜନ ପରେ a short date may fix for take the instruction millers otherwise notice can be issued millers
no question of illegal notices being issued
then lords
after reading directly and from the face of Rajesh versus Neha I will entertain the petitions when you are not when he is bargaining with you and first he will bargain with you then with the court so this is not a marketplace for bargaining decrees passed by the court and Supreme Court direction ସେ ଯଦି ଦେବେନି ତାଙ୍କର କିଛି ଅସୁବିଧା ହଉନି ସେ ତାଙ୍କ କଥା ବୁଝିବେ why the court will enter the arena see when who is seeking equity must do equity he is seeking interference by the court it's a money decree
may I bring one thing
sir in fact before Rajesh versus Neha CPC is there
millers
is there that how the decree has to be enforced what role of the appellate court article 151 re kahin ki the security is in because unless it is secured what the court will adjudicate ସେ ଧରନ୍ତୁ ବିକିକି ସବୁ ପଳେଇଲେ ତାଙ୍କ ଜମି ଆପଣଙ୍କୁ ବିକିଦେଲେ ସାର୍ ଆପଣ ସବୁ ଜାଗା ମୋର ନିଅନ୍ତୁ ରଖନ୍ତୁ ଆପଣ ଖେଳିଦେଲେ ତାପରେ ହି ବିକମ୍ସ ଏ ପ୍ରପର so there are so many aspects it is nothing new sir enforcement of a decree ଟାକୁ ଏଥିରେ ଇଣ୍ଟିଗ୍ରେଟ କରାଯାଇଛି The learned counsel for the petitioner was heard at some length. The petitioner kindly take your seat. I'll dictate the. ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି ଏଇଟା?
6-7 दिन टाइम देले भी पाइजो
The petitioner's husband is before this court challenging the judgment dated 37/2025 passed in criminal proceeding number 131 of 2021. The कौन लिखे नंबर लिखी ले The said proceeding was initiated under the provisions of section 125 of CRPC into brackets since repealed. Complete করে bracket and substituted by parametric provisions contained in it. Bracket closed by the wife in the marriage and minor child aged about 3 years represented through the mother. Minor child born from the wedlock aged about 3 years born from the wedlock. The monthly maintenance sought for the wife was rupees 30,000 and for the child was rupees 20,000 per month. However, the Learned Judge Family Court has directed payment of monthly maintenance rupees 3,000 per month for the wife in the marriage and rupees 5,000 per month This is a fit case where the risk is that, like Supreme Court, they enhance it. 3,000 will get enhanced to 13,000. Because why he is granting 3,000? No reason is given. The monthly salary and everything is proved. High Court, Odisha High Court has a decision.
Millers.
Odisha High Court decision is 25%, at least. So, anyway, I am not discussing on merits. I am just passing the order.
Millers.
For the minor child. Para. In view of the judgment and direction of the Honorable Supreme Court in Rajneesh versus Neha, the amount of maintenance directed under section 125 CRPC is in the nature of a money decree. The learned counsel for the petitioner has adjournment to obtain instruction how the amount shall be secured for challenging the same before this court, and what amount has already been paid during pendency of the said proceeding or after pronouncement of the judgment dated judgment dated Mr. Pushpan?
The series.
Yeah, it is.
Series
Data पकड़ देबे हो?
37.
At the rate of 8,000, तापर stop करी सब पार करो. At the rate of 8,000 per month, the amount is due from 13/7/2021. For 54 months till February 2026. 5 months will be February 2026. 55 months. The amount due would be 8,000 गुणन 55. बुझी परिबेन? Yes. Okay. We are studied in both the same school. We have the same mathematics teacher. So, yes. Sir, continue the week. Listen the week commencing nothing.
I'll take care. Okay.
Please.
I get this.
Listen the week commencing tasting.
Tasting Millers.
We are on actually the dates are similar. That is facing confusion. Probably that Monday hochi 2 sethipai.
Again.
But our masters आरंभ होते
23 Millers.
Today we are on 24th.
Millers.
19.
Mr. Rajkishore Swain.
My lord. Well, this case has been placed for the maintainability of law or writ application. So against the order of the sub-collector, my lord, for acquisition of land for the purpose of the NHI authority. The reference case was filed under section 64.
এটা তো স্টাফ রিপোর্টিং ମୁଁ କରିପାରିବି ନା ରିପୋର୍ଟଟା କଣ ଦେଖୁନାହାନ୍ତି
The law ho many cases
ଡେପୁଟେସନ ଲଜିମାରେ ଆସିଲା ଆପଣ ଚାହୁଁଛନ୍ତି କଣ ଆପଣ ଚାହୁଁଛନ୍ତି ଲା ହବ
ହଁ my lord ସବୁ ବହୁତ law case ବି
ଆରେ ବହୁତରେ କେମିତି ହବ ସାର୍
64
କେସ୍ ତ ଷ୍ଟେ ହେଇକି ରହିଛି ହବା କଥା ନୁହଁ ସେମିତି କଣ କୁହାଯାଏ ମାନେ ଆପଣଙ୍କର ଲିଗାଲ ସବମିଶନ ମତେ ଟିକେ ବୁଝାନ୍ତୁ ଆଇ ସିକ୍ ୟୁର ଆସିଷ୍ଟାନ୍ସ
So my lord 64 against a reference to the collector and collector is the notified authority of the area. Collector rejected the application.
ବର୍ତ୍ତମାନ there is a designated authority
Collector.
ନାଇଁ ଆପଣଙ୍କର in the rank of a senior district judge ତ କଣ ସେଟା ରିଲିଫ ରିହାବିଲିଟେସନ ଆଣ୍ଡ ରିସେଟଲମେଣ୍ଟ ଯୋଉଟା କୋର୍ଟ ଗୋଟେ ହେଇନି ଲାରା ହଁ ଆପେଲେଟ୍ ଆପଣ ସେଟା ବି ଏକ୍ସାମିନ କରନ୍ତୁ ଆପଣ ଯଦି ଜଷ୍ଟ ଆପଣ ବି ଟିକେ ଦେଖନ୍ତୁ ଏଇ ଜିନିଷଟା ସବୁ ଜିନିଷକୁ ମୁଁ କେତେ ଏକ୍ସାମିନ କରିବି ଆପଣଙ୍କର ଏବେ ଗୋଟେ ଷ୍ଟାଚ୍ୟୁଟରୀ ଅଥରିଟି ଆସିଯାଇଛନ୍ତି and ସିଏ ବି ଆପଣଙ୍କର they are entertaining and then examining all the facts your advantage would be that it is a fact finding authority ବି ହେଇପାରିବ ମାନେ obviously not new facts cannot be adduced but at least they will be discussing the facts
We redressed it for the collector in view of 64 of the reference to the authority. Thereafter we are coming to the High Court.
see arbitrator NH authority ରେ ତାପରେ ଏଥିରେ in fact there are decisions on this I'm simply assuming ଆପଣ ବି ଦେଖନ୍ତୁ ଗୋଟା ଗୋଟେ ହେଡିଂ ରେ କରିଦେଲେ ସବୁ DLAA 55420 of 2025
ସେଟା expeditious disposal ପାଇଁ କରାଯାଏ
ଆପଣ expeditious disposal ପାଇଁ ପେଣ୍ଡିଂ ଅଛି ବୋଲି କହୁଛନ୍ତି ସେ disposal କରିବେ
ସେ ପେଣ୍ଡିଂ ଥିଲା expeditious disposal ପାଇଁ ରିଟ୍ ଫାଇଲ ହେଇଥିଲା
ହଁ ତାପରେ
ସେଟା disposal ସେ କରିଦେଲେ କରିଦେଲା ପରେ 74 ରେ ଆମେ ଲାରେ ଆସିଲେ
ନାଇଁ ଆପଣ ତ ଏଇଟା ଗୋଟେ NH ଆକ୍ଟ ଗୋଟେ ସ୍ପେଶାଲ ଆକ୍ଟ ନା
yes
ତା ପ୍ରୋଭିଜନ ରେ ଆପଣ କେମିତି କହୁଛନ୍ତି ଲା ହବ ବୋଲି ତାହେଲେ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ଆକ୍ଟ ରେ କଣ ହବ କମନ ସେନ୍ସ କମନ ମାନେ ବେସିକ ପ୍ରିନ୍ସିପଲ ସ୍ପେଶାଲ ଷ୍ଟାଚ୍ୟୁଟ ରେ ଯଦି ଆପିଲ ପ୍ରୋଭିଜନ ନାହିଁ
3 ଇୟର ତ ନୋଟିଫିକେସନ ହଉଛି
ସେମିତି କହିଲେ କେମିତି ହବ ସବୁ ତ 226 ରେ ଅଛି ସବୁ ଆପଣ କନଷ୍ଟିଟ୍ୟୁସନ ରେ ଅଛି ସେଇଟା କଣ ଆର୍ଗୁମେଣ୍ଟ ଆପଣଙ୍କର ସ୍ପେଶାଲ ଷ୍ଟାଚ୍ୟୁଟ ରେ ଆପେଲେଟ୍ ପ୍ରୋଭିଜନ ଅଛି କି ନାହିଁ
yes ଅଛି 74 ରେ ଅଛି
କାହା ପାଖରେ ଅଛି ସେଇଟା
ଅନରେବଲ ହାଇକୋର୍ଟ ପାଖରେ ଅଛି
ସେଇଟା ଆପଣ ସାବ ରିପୋର୍ଟରଙ୍କୁ ଦେଖଉନାହାନ୍ତି
appeal to the High Court
କଣ ପଢିଲେ ସେଇଟା
the requiring
ପଢୁଛନ୍ତି ତ
yes sir now your lordship right to fair compensation and the transparency of the
ସେଟା କଣ ଚାଲିଗଲେଣି ସେଟା ହେଲେ ତ ଲାକୁ ଯିବେ ସେଟା ନୁହଁ ମୁଁ ପଚାରୁଛି NH ଆକ୍ଟ ରେ ଆପେଲେଟ୍ ପ୍ରୋଭିଜନ କଣ କି ଅଥରିଟି ଆପଣ ଇଣ୍ଟରପ୍ରିଟେସନ ଥିଲା ଆପଣ କୋଉଠି ପଢୁ
ଆଜ୍ଞା MS ରେ
କଣ କଲେ 31/12/2025 indicates that the question of maintainability has been pointed at defect number 9. The land acquisition appeal has been filed under the provision of ଆପଣ କୋଉ provision ରେ file କରିଛନ୍ତି? Section 74 of right to fair compensation and transparency in land acquisition. लिखिए पूरा है ना Rehabilitation and Resettlement Act 2013 challenging the order passed by the collector cum arbitrator district collector come arbitrator. In LA arbitrator case number 67 of 2024 under section 3 into bracket capital G of National Highway Act 1956. अच्छी अपन पर बही अच्छी apparently the बहुड़ा सब रखिबे ना apparently NH रखिबे special. Apparently the staff reporter has raised the issue of maintainability of LAA as the order is by the statutory authority under the NH Act 1956. The learned counsel for the petitioner as well as the learned counsel for the state have adjournment to address on the said issue on the next date. National Highway Act ଆଣିଛନ୍ତି ଅଛି ସାର୍ ନାହିଁ ସେଥିରେ ଆପଣଙ୍କର ଅଛି 3J Land Acquisition Act 1 of 1894 not to apply. That is how it is a special statute. Said issue as the section 3 capital J of NH Act 1956 provides that Land Acquisition Act 1 of 1894 not to apply. The learned counsel for the petitioner shall also address regarding applicability of the RFCTLAR and R Act 2013 to the national highways, to the acquisitions made on the National Highways Act, 1956. So you must understand when there is a lack of jurisdiction by this court or the collector or the LARA authority, any amount of prosecution, this matter is kept pending here for say 2 years, 3 years, or 5 years. Ultimately, the petitioner doesn't get anything. If it has to be a read petition, it has to be a read petition.
Already, Lordship,
no, I don't know.
Under section 34 of the Arbitration Conciliation Act, they have to challenge the award.
But should I say examine korantu? When it is arbitrator, I have seen also that arbitrator's award has been 34 before the district judge.
But commercial court
now commercial court. But also National Highway Act. So upon set examine korantu.
Yes, sir.
34 ହେଲା ତାପରେ ଆପଣଙ୍କ ହାଇକୋର୍ଟ ତାପରକୁ ଆସିବ arbitration appeal ରେ ଯାଇକି 37 ଅନ୍ୟ ଗୁଡାକରେ ସେଟା ଟ୍ୟାଗ ହେଇଛି କଣ ଅର୍ଡର କରିବେ କନେକ୍ଟେଡ ରେ କଣ କରିବେ ମିଷ୍ଟର ସ୍ୱାଇଁ
Mallet Chairman. So all are equal.
ତାହେଲେ in view of the order passed in so and so କେବେ ଆସିବ ମିଷ୍ଟର ସ୍ୱାଇଁ କହିଲେନି
After 1 week year ଆସିବ
ପ୍ରଥମେ ଦେଖିବେ this in the week commencing 23 ନା 30 କେବେ ଚାହୁଁଛନ୍ତି
30
week commencing 30 ହେଲା ଆଜ୍ଞା ହଁ the in view of the order passed in the tagged the connected matter DLA te list on the week commencing. Yes, next.
Item 20 instruction on behalf of the opposite party.
Ayun to more malot. Comment.
20, Mr. Rockman, you are there.
I am for the, I am 20, I am for the 20 petitioner.
Again,
I am for the petitioner 20. I did 20.
Democratic.
20.
Sumit Kumar Swami.
This someone.
No, no.
Yes. I don't know. Complete.
20 TRPC.
I'm sorry. I'm sorry. I'm to keep. I'm sorry.
your name, madam?
Yes, Sukhanti Sahoo.
Miss MS S. Sahoo for the petitioner. So, your name?
Abhishek Mohanty.
Mr. Abhishek Mohanty. No, it's blank rowing.
Saileja Nandan Das.
Pore likhe padiyo. Yeah. It is submitted by the Learned Counsel, Mr. Abhishek Mohanty, that Mr. Saileja Nandan Das, Learned Counsel, and Mr. Mohanty, Mr. Mohanty and associates have instructions to appear on behalf of the opposite party. वकालतनामा फाइल कर लेना करिबे केबे के दिन लगे
गोटे दिन
stop. He submits that wakalatnama, duly executed wakalatnama on behalf of the opposite party shall be filed within 3 working days. The wakalatnama, upon filing of the wakalatnama, the same shall be taken on record. The scanned copy be updated. Name of Mr. Sarajanandan Das, Learned Counsel and Learned Associates shall be reflected in the cause list as well as the case brief upon filing of the wakalatnama appearing for OP. You have received copies?
Yes, ma'am.
List in the week commencing, delay is there. ना जानना ठीक अच्छी लिस्ट इन द वीक कमेंसिंग 23/3/2024. Yes, next. In this one.
21.
Mr. Akshay Kumar Sahu for the petitioner. Yes, please. No, your name is Akshay Kumar Sahu.
Well,
Upon Akshay Kumar Sahu. Yes, yes.
Humble petition of the the wrong constitutional of the petition wrongly typed. The permitted to amendment another.
মানে আপনার জিওএপি হবনি
cost title CP number is wrongly typed.
আচ্ছা আপনার typographical mistake in the cost title.
Yes, ma'am.
It is submitted by the Learned Counsel for the petitioner that some inadvertent typographical errors have crept into the cost title of the petition. He seeks leave to file corrected cost title. ଆପଣ କଣ ହାତରେ କରେକ୍ସନ କରିବେ ନା ଟାଇପ କରିକି ଦେବେ?
ନାଇଁ ଟାଇପ.
କଣ ଲେଖିଲେ? He seeks leave to file corrected typed corrected cost title within
tomorrow
within 7 days.
Yes.
Within 7 working days.
Okay.
Upon stop. Prayer is allowed. Leave granted to file corrected typed cost title. Yes. List in the week commencing? Not in the 14 KFC day period. Your week commencing not in. Along with the corrected cost title.
22.
Yes, please. Mr. Patnaik, you are there for the petitioner?
No, madam. For the respondent. For the petitioner.
You are for the petitioner. You are Mr.
On behalf of Prabir Kumar Rai.
Your name, sir?
Kolakarnu Vishwal.
Power nahi?
Nahi, on behalf of Prabir.
Mr. K. Vishwal.
Yes.
Kamalakanto?
Kolakarnu Vishwal.
Kolakarnu Vishwal. Mr. You write KK or K?
K.
Mr. K. Vishwal on behalf of Prabir Kumar Rai for the petitioner. The petitioner has obtained change. आगुरु जे काउंसिल थिले से कंसेंट देके आपण अपेयर करछंती बहुत गुडे ना बाहरची
सॉरी
आगुरु सिद्धार्थ प्रसाद दास एसके महांती तापर लेखाई छी प्रबीर कुमार राय
हां प्रबीर कुमार
सिद्धार्थ प्रसाद दास कोन आगुरु अपेयर करथिले
नहीं सेम गुड पेपर
ए दिथर कोन हेची मु सेत पे मिस्टर माइल बिशप पटनायक अपेयर करछंती
नो मैडम आई एम अपेयरिंग फॉर द रेस्ट
सिद्धार्थ प्रसाद दास प्रबीर कुमार राय एका चाहे मे बी आवर मिस्टेक हम रजिस्टर भूल भाल लिखते ये कौन तो सर दिस योर पिटिशन
Yes, yes.
यू वांट टू आर्ग्यू और यू वांट adjournment कौन चाहूଛନ୍ତି कौन
नहीं आर्ग्यू
प्लीज कौन तो
सर आम ट्रांसफर पे ही अपील करथिलु
यस
से लेडी सिंगल लेडी एकुटिया रहउचंती कहार सपोर्ट नै हस्बैंड रो सपोर्ट नै एपर्यंत किछि मेंटेनेंस मिलेनी तांको पेरेंट्स भी दिल्ली वे
मेंटेनेंस
नै
रिलेटेड
सी
से ऑर्डर
से भुवनेश्वर रे रहउचंती तो सी
सिंगल हस्बैंड कितना केस करछन
दीटा
तो केस कला तो बहुत तंकर सिंगल जणा पडुनांती पांचटा तीनटा दीटा केस तो कर करछंती तले एथे तो से डिफेंडेंट से कोठी केस करछन
भुवनेश्वर
से करछन भुवनेश्वर रे सो हाउ डज इट टेक क्राइटेरिया दैट जे जोटी केस करबो जा ना रे सेठी सब जा केस हबो बोली
ना सर सी
you see somebody is facing a trial being implicated in so many cases and he doesn't have a choice, he is the dominus litis, he has to be compelled to go to some place where the lady prefers to file cases against him. What is this logic? Movie upon the one podini actually. This kind of case law also I have not read. Little bit of understanding or reading what I make. What is the logic behind this? ଆପଣ single lady ଆପଣ ପାଞ୍ଚଟା କେସ୍ କଲେ ହଜବେଣ୍ଡ ଙ୍କ ନାଁରେ କି ଦିଟା କରିଛନ୍ତି ଆପଣ ଯୋଉଠି କେସ୍ କରିବେ ସବୁ ଯାକ କେସ୍ ସେଇଠି ହବ. What is this logic? And such a provision in the law also, section 19, where they last resided, the petitioner resides, or if the respondent is not residing, then wherever he or she, even ଆପଣ ଯଦି ରହୁ ନାହାନ୍ତି ଆପଣ ତାହେଲେ କେସ୍ କରୁଛନ୍ତି ଆପଣଙ୍କ ଜାଗାରେ ସେ କଣ କରିବେ ଫେରେ ତାଙ୍କ ଟ୍ରାନ୍ସଫର ଆପଣ କେସ୍ ସେଠି ଟ୍ରାନ୍ସଫର ହବ କି ହବନି ତ ଦେନ୍ how does transfer of a case improve the financial conditions? Sir, तुम पचारले आपण आंसर देलेनी
नहीं सी
pass that order due to the financial stringency of the lady, the case needs to be transferred to so and so court. Then I have to give a reason how it improves.
फाइनेंशियल बर्डन कमी जीवो माय लॉर्ड
केमती कमी जीवो सो दैट यू हैव टू से
ट्रांसपोर्टेशन कॉस्ट एपुटु जिबा सेवा कॉस्ट
ट्रांसपोर्टेशन कोठी आपन कॉस्ट कमी जीवो कोठी
सी तांकर गोटे 4 इयर्स रो गाल अछि ताकू धरि कि
सर आपन कोर्ट को जीवा कथा नो गाल को नेकी आपन को नियरेस्ट धरन आपन नेक्स्ट डोर मेंबर कोर्ट आपन धरन समाव आपन पाटरे रहउछन कोर्ट भितरे आपन को छोटो जीव को नेकी जिबे so that don't make arguments which do not sustain anyhow do not sustain any logic. ଯାହାର ଛୋଟ ଛୁଆ ଅଛି ତାଙ୍କ ଘରେ ଧରନ୍ତୁ ତାଙ୍କ ଘରେ ବି କୋର୍ଟ କରାଯିବ କଣ ସେଠି ଛୁଆ ପ୍ରଡ୍ୟୁସ ହବ ସୋ ହାଉ ଡଜ ଇଟ୍ ଆପଣ ଛୁଆକୁ ଯେତେବେଳେ ବି କେସ୍ କରିବେ ଯୋଉଠି ବି କରିବେ ଆପଣ ଯୋଉ ପାଞ୍ଚଟା ଦିଟା କେସ୍ କରିଛନ୍ତି ଛୁଆକୁ ନେଇଯିବେ ସେଠି ସାକ୍ଷୀ ଦେବା ପାଇଁ ଦେନ୍ ଯୋଉଦିନ ଆପଣଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ ନିଆଯିବ ଛୁଆକୁ ନେଇକି ଯିବେ କି ସୋ ହ୍ୱାଟ ଇଜ ଦିସ୍ ଲଜିକ ଯେ ଛୁଆ ଅଛି ତେଣୁ ଆମେ କୋର୍ଟ କେସ୍ଟା ଗୋଟେ ପର୍ଟିକୁଲାର ଜାଗାରେ ହବ ୟୁ କ୍ୟାନଟ୍ ଟେକ୍ ଦ ଚାଇଲ୍ଡ ଏନି ହାଉ ୟୁ ହାଭ୍ ଟୁ ଲିଭ୍ ଦ ଚାଇଲ୍ଡ ଇନ୍ ଦ କେୟାର ଅଫ୍ ଗ୍ରାଣ୍ଡ ପ୍ୟାରେଣ୍ଟସ୍ ଅର୍ ୟୋର ବ୍ରଦର ସିଷ୍ଟର ହୁଏଭର.
She is not staying with their grandparents as well.
Grandparents. So let us not keep on shifting the point. Let us finish one point. First, you are saying the financial stringency will be improved if the case is transferred. And how it will be improved? So she can appear in VC. Wherever she stays, she will file a petition that I will appear in VC. For passing an order, I must give some reason. And after the CP is filed, you file 498A, domestic violence. I'm giving an example. Domestic violence, 125. And maybe nowadays, in-laws are filing domestic violence case against the lady also. Usually the mother-in-law and sister-in-law, they file. That is happening. So where does it end? What is the logic that wherever the petitioner files lady files 3-4 cases, there all the cases should be transferred. And ultimately, you want expeditious disposal of the matrimonial cases. That's a concern. That's a general concern. A comment on the judiciary also that we are keeping the matters pending matrimonial causes. Maintenance cases are kept pending for 7 years, 8 years. Interim maintenance also, or not even 25 final alimony. So how does it help you? It doesn't help. ଆପଣ କୋଉଠି ଚାହୁଁଛନ୍ତି? Bhubaneswar is a place that is extreme pendency. And the distance, they are twin cities and say rahuchandi koti.
Delta Chakku.
Delta Chakku Kotak will be easier to reach in highway.
If I may.
ଆପଣ ଯଦି ରାଜି ଅଛନ୍ତି ତାହେଲେ it's a different thing. many times to expedite the matter, instead of keeping the matter pending here for nothing. You may agree, but Court of Orissa, in fact, I have already pronounced judgment.
Lordship, what have happened in this case, Lordship? Since 19/12/2017, because of the interim order, Lordship, matter is pending. Divorce case is being stagnant, Lordship.
I know. I didn't, when I was discussing with Mr. Mr. Korakanu, Mr. Bishwal. So I didn't mark that it is 2017 now, we are completed 9 years.
And Lordship, the distance is hardly 20 kilometers, but in the petition, Lordship, they're taking 80-kilometer distance between Cuttack and Bhubaneswar.
No, that is happening. Today, the distance between Baripada and Baleswar has increased to 100 kilometers. So in matrimonial, when transfer is sought for, usually the distance is increasing. Obviously, it can increase. So for instead of coming from Baleswar to Baripada, you come to Bhadrak, then go to Anandapur. Then Anandapur to again go back to that to Bhadrak, then to Baripada. It will be 150 kilometers.
मतलब दीटा पॉइंट सी तांको पेरेंट्स भी ताको रखी पारु ना तो फाइनेंशियल बर्डन जो से जने से
give that reason in my judgment that in by transferring the matter to Bhubaneswar, the parents will start keeping the lady. The lady will stay with her parents. You must understand what you are arguing should be germane to the issue. So the test is for an administrative action, but similar to the judicial pronouncement also. You want to you cannot travel to the court at Cuttack, but you can travel to Bhubaneswar. I have to write that or not? How can I do that? In a twin contiguous city, then what about the applying the same logic to city state like Delhi? You must understand that also. That the way you are portraying the distance, though it has increased by filing the application to 80 kilometers between Cuttack and Bhubaneswar. Nothing, sir. You have only stalled the proceeding, and now after 9 years, this question I asked Mr. Ponda. After 9 years, I direct transfer of the matter because you have stalled the proceeding. This case will be the case of 26 or 2017? 26. In Bhubaneswar, with this huge burden of cases, even after establishing 2 family courts, so many, because the marriages are happening in Bhubaneswar. That is how the original jurisdiction is there, section 19. Also, maybe the litigants are comfortable in Bhubaneswar and Cuttack. Could be. I don't know why they are not going to other places. There is extreme pressure on the family court for these matters. I convert. Instead of expediting the matter, I convert a 17 matter to 26 matter. Disposed of with that paragraph that if you want to avail any kind of ICT facility, in 17 maybe it was not that much in vogue, but now it is available. You can appear in remote location, depose in remote location. But that will not help you also because nowadays that thing is also cramped. There are so many persons requiring to use the ICT facility and staying in Bhubaneswar, you do not want to come to Cuttack when the matter is prioritized. 2017 matter. ଗୋଟେ କଟକ ଭୁବନେଶ୍ୱର ଗୋଟେ ଥିଲା ଗୋଟେ ଅର୍ଡର ଦେଖିଦେବେ ତା ପାଖରେ ଅଛି କଟକ and Bhubaneswar being contiguous city distance 20 kilometers ତା ଥିଲା to disposed of with that paragraph ତାପରେ ଲେଖିବେ the parties shall since the matter is kept pending since 2017 before this court the lauded judge family court Cuttack is requested to take up the matter expeditiously as per the available as would be permissible in his board. The parties shall cooperate in the expeditious disposal of the matter and shall not take any unnecessary adjournment. Apanakar conciliation usually apan asi eta stay karthibe. What usually happens once the notice goes for conciliation, come to High Court, file a TRPC and get stay. इतने कौन से स्टेटस इतने अपील भी करना चाहिए.
No, my institution, they have not appealed, Lordship. And Lordship, after initiation of the CP case, FR was lodged. Thereafter, TRPC case, matter stayed and still date matter is not been adjudicated.
कौन करे ଆପଣ ସେଥିରେ appeal ବି କରୁନାହାନ୍ତି ଆପଣ ଭୁବନେଶ୍ୱର ଯେ କରିବେ କଣ so it is better you do it here and you yourself can attend the case here. He will attend the trial. I'm not saying that you should, but I'm just giving example. What is the difficulty? There is absolutely no difficulty. Yes, next please.
Grateful. Bless.
23.
Yes.
23, my lord, the issue is the second RCP to the teachers. And it was
served. Upon copy penalty.
No, my lord, it can be disposed of their file count. No, I'm
Filed in 21.
I'm trying just 1 minute if it can.
Yes.
This is the second RSCP issue of the teachers. It was granted. These are joined in 1994. Second RSCP given sometime 2014. So it was initially granted for 4,200. Then the department took the view that these teachers doesn't possess the requisite qualification for promotion. Therefore, the grade pay of the promotional revenue cannot be granted. So that was challenged before the tribunal. Tribunal passed the order in our favor. Then the state came to this Hon'Ble Court. Several cases. So this Hon'Ble Court also resolved the issue in the favor of the teachers that 4,200 is payable. Then the state took it to the Hon'Ble Apex Court. There also they have considered to grant us, and there is a direction directly from the Hon'Ble Apex Court to implement the High Court's order within a stipulated time. So that's the. So there is similar orders is there. If you
yes, Mr. Sahoo.
I have to go through the case.
Then provide कर दियो. So Gauri Mohan Ratha.
ଖାଲି ଆପଣଙ୍କ କପି ଲର୍ଡସିପ ଇନ୍ ଲେନ୍ଥ ଅଫ ଦି
ତାଙ୍କୁ ଦିଅନ୍ତୁ ତାଙ୍କୁ ଦେଇଦିଅନ୍ତୁ
ଗୋଟେ କୋର୍ଟ ରେକର୍ଡରେ ବି ରଖ
of course I will refer to that. Mr. Gauri Mohan Ratha for the petitioner, Mr. P.K. Sahoo for the petitioners plural, है ना? Mr. P.K. Sahoo for the opposite parties.
ଗୋଟେ ମିନିଟ୍ ଦେଇ
ଏଇଟା ମୁଁ ଦେଖିଛି
ଗୋଟେ ଦେଇ ଦଉଛି ଖାଲି ମୁଁ ଜଷ୍ଟ ପ୍ଲେସ୍ କରିଦଉଛି where it is stated.
The learned counsel for the petitioner submits that. I will make you the matter is listed for admission hearing or for hearing at the stage of admission. It is submitted by the learned counsel for the petitioner that the issue involved in the writ application has attained finality. After it has been carried to the Honorable Supreme Court, and the Supreme Court has held in favor of the petitioners. Not petitioners, in favor of persons
teachers
similarly situated as the petitioners. The petitioners are assistant teachers in various primary schools under the government.
Yes, ma'am.
Under the government. Grant of grade pay of rupees 4,200 as second revised assured career progression benefit into bracket RSCP. Progression benefit ପରେ RSCP ତାପରେ benefit लिखी. Revised assured career progression into bracket RSCP benefit is the matter of contention between the petitioner and the opposite party state. The petitioners were granted RSCP grade pay, the benefit of RSCP in form of grade pay at rupees 4,200 from the year 2015. 2014. Upon 15 lekha hai 2014, which was reduced to the rupees 2,800. The petitioner number 1 approached the OAT in OA number, OA number dash.
ওই নম্বর 2501 2502
কি দিবেন
এই লেখা অর্ডারটা লগেজ অর্ডারে লেখা
ওইটা দেখি তো লিখ দেবে ওই নম্বর
11 at page
which was disposed of বাদ দিলে পেজ 11 লিখতে হবে which was
disposed upon
which was disposed of by order dated 5/12/2017 directing to refix the grade pay at rupees 4,200. The orders were challenged by the state by filing ଆପଣଙ୍କର ଏଇଟା same set of ଅଲଗା ଲୋକ
ଅଲଗା ଲୋକ
similar orders were challenged କରିଦିଅନ୍ତୁ. Similar orders were challenged by state by filing writ applications before this court. That is WPC number 7281 of 2018 and WPC number 4848 of 2021.
And many of them.
The writ applications were please confirming the orders of the learned tribunal. Against similar orders passed by this court by division bench. It did writ applications challenging the orders of the tribunal. A batch of SLP special petitions were filed before the apex court, which have also been decided in favor of the petitioners by dismissing the SLP. Copy of the judgment dated 24/6/2022 passed in WPC number 7281 of 2018 and WPC number 4848 of 2021. Passed by the division bench of this court is produced by the learned counsel for the petitioner. Copy is also served on the learned counsel for the learned assistant standing counsel for the state. The learned counsel for the petitioner also produces copy of the order of the Hon'Ble Supreme Court dated 9/9/2025 passed in civil appeal number 11486 of 2025. Colon State of Odisha and others versus Panchanan Panda.
Batch of
Panchanan Panda and batch of cases, wherein the apex court have dismissed the SLP and confirmed the order. The copy of the said SLP order is also copy of the said order with the civil appeal is also served on the learned AC. The learned AC has adjournment to respond to the this sequence with final agreement.
there is a time bound
This in the week commencing କେବେ କୁହନ୍ତୁ 23 in the week commencing 23/3/2026. Yes, next please.
24 same here he has not gone for the OA. There is no OA has been filed here.
24 लिखिए Mr. Gauri Mohan Datta for the petitioner, Mr. P.K. Sahoo, AC for the opposite party. It is submitted by the learned counsel for the petitioner that the matter is similar to the WPC number 10080 of 2020, which was heard at some length and has been adjourned to the week commencing 23 3/20/26 stuff. Accordingly, the present writ application shall be listed along with the said WPC 10080/2020. This much. Yes, next. Mr. Author, please your matter. Item 25.
Item 25.
My lord, the petitioner has challenged in this writ application the advertisement issued by the Utkal University for the post of chief librarian by fixing an age of 45 years as the entry to the service, which is not prescribed under any provisions of the university statute. I would like to draw my lord's attention that your lordship may have a look to the advertisement that was earlier issued, and that will be at page annexure 1.
Yes, please. Okay.
This advertisement annexure 3 at page 24.
Yes.
On 7/8/2019, Utkal University published an advertisement, whereas the page 25, chief librarian at clause 3 of last one paragraph above the bottom, age of superannuation is 60 years at page 26. Requirement which my lord can have a look to at clause 3, a master's degree in library science, information science, documents with at least 55% marks or equivalent grade of B in the UGC 7-point scale and consistently good academic record, but out of these regulations, set up out of these regulations. At least, this is my more important matter, at least 13 years of, as a deputy librarian in a university library or 18 years experience as a college librarian. This is the minimum requirement, my lord. Then your lordship may kindly come to page 26. Age of superannuation is 60 years. That's the reason as to why, my lord, the age of entry to the service has not been mentioned or is prescribed. As because if a person is to have 18 years of service, the requirement of for eligibility, the question of entry age was not prescribed anywhere. Your lordship can have to next to this advertisement which was given. The 2 months thereafter, it was published. They have given it to the email. Thereafter, that was not attended. 3 days after, this was taken out. So nobody could have applied. Those who could have applied within 3 days is all right. So this was not acted upon. 2 months thereafter, annexure 4 at page 27 may kindly receive. The advertisement was issued on 16/10/2019 for the post of chief librarian. And for your lordship's kind attention at page 28, very same eligibility criteria has been prescribed. 1, master's degree, etc. my lords, at least 13 years of as a deputy librarian, university, or 18 years experience as a college librarian. Age of superannuation. No entry age has been prescribed there. Age of superannuation. Then your lordship can have a look to this advertisement. I applied because I qualified everything because I was having a postgraduate qualification in library science. I am a PhD degree holder, and I had the experience that required for application to the post of chief librarian. My application was entertained, was received, along with the deposit of 1,000 what they wanted. While that matter was pending, on 3/11/3/12/2021, annexure 5 was published. You lost me at page 29. There they have made a mention at last paragraph, that first page, the advertisement issued on that is hereby cancelled, and candidates who have applied for the above post are required to apply afresh. I would like to emphasize afresh. And the condition was that your lordship can have page 30. Master's degree in library science, information science, documentation with at least 55% marks or its equivalent, and consistently good academic record set out in these regulations. 2. At least 10 years of experience in library science or librarian of any college, university, recognized institution and offices. Then your lordship will consider other things. Age below 45 years. My humble submission is keeping somebody's mind this advertisement is issued so that I cannot apply. I had applied earlier. That advertisement which was in process was cancelled. A condition, those who have applied, they have to apply afresh.
So, Mr. Ratha, is it your case that those who had already appeared on the advertisement was cancelled, they are debarred to apply again?
Yes, my lord. Debarred because I do not come within the age of 45.
So they cannot be considered along with this, the fresh. Mr. Patnaik is appearing.
Yes, Mr. Tara.
Mr. Patnaik.
My lords.
In the second advertisement, you have specifically mentioned that the earlier advertisement was cancelled.
Yes.
But in the interim, if somebody is disqualified by age or otherwise, by age, basically age, not otherwise, because one cannot retire. What cannot happen? Suppose let us assume that between the two advertisements, one attains the age of superannuation, 60 years. But if somebody crosses the age, then he or she cannot apply.
No, because this particular petitioner.
No, I'm not saying. I'm making a general question. I cannot take. I do not know what happened to this petitioner. Because recently, there are so many pronouncements. Apart from COVID. COVID is there because I have one judgment in COVID 2021 after that the state governments have considered and they have granted. But here is a case that first advertisement, there is second advertisement, third is there or second?
This is the third, my lord.
Third is there. 3 advertisements. First has not culminated any selection. Second has not culminated any selection. Third is to be considered.
My lords.
In the process of first 1, 2 and 3, first, second and third advertisements, the candidate who was applied in first becomes overaged by the third advertisement. How can you debar?
That proposition.
Common proposition I can give you because that comes to immediately to Malik Mazhar Sultan. Every year High Court has to do a test mandate, now statutory mandate. Malik Mazhar Sultan says every High Court in India has to conduct a recruitment test. For some reason, the High Court is unable to do a test. So next year, the High Court has to allow the earlier year. Now the question is that if the process has culminated in a selection or otherwise, that's a different thing. Say Malik Mazhar Sultan, High Court today, the last year has not done. You must be thinking that how easily I can give you example because that's now you can understand that how it came to my mind. Last year the direct selection has not been done. Say 25. I'm giving 25. It doesn't culminate any selection. 26 I am advertising. Not I am. 26 is advertised. Then 25 cannot be given a go by. Both ways. Here you have advertised, but not culminated in selection. Not advertised, no selection. Usually the case is not advertised, no selection. COVID. That police recruitment, the division bench judgment of Justice Sinha sitting with me. They cited Uttar Pradesh. State government said 3 years. Because COVID is 3 years. Now, in fact, they are not satisfied. They seek that lock, stock, barrel. Whoever is, waiting for an appointment, 5 years, 10 years, that's a different thing. That's an extreme case. So this is the common service jurisprudence. What one of the learned counsel told me, like you, who's appearing for university, that they decide what is the law. So that cannot be. Maybe the lighter one is
Eligibility criteria, etc., can be fixed by the
no,
authorities.
but not this way. But there are several. So that is why I give you an immediate example. That if there is continuous advertisement, 3 advertisements, then how can you ignore the earlier advertisement? That is the question to you.
And that has to be in tandem with law.
No, you cannot ignore. You cannot ignore. Malik Bajar Sultan is a judicial for courts. That's thing, but that's the law also. Malik Bajar Sultan is not very. I mean, something extraordinary as far as Malik Bajar Sultan does not say that there will be eligibility criteria. It says that you conduct every year.
Exactly.
So it is conducted every year. If not conducted, then how can you ignore the earlier batch? Now, in your case, it is a step ahead. You conduct, but you ignore the advertisement. They can get disqualified by any means. That's another thing. Mark that can be. But if it is advertised, they are qualified. They are eligible to apply. In that sense, I can say qualified. I cannot say whether qualified or not because I am not assessing the eligibility. They are qualified. They are eligible to apply. Then the second, third, fourth, you may go for seven also. Till you are satisfied that enough candidates are there. No, it is happening in some other service in UPSC that I have seen because as a lawyer I have seen that. So, but I cannot. Perhaps I cannot do.
When the candidates are less, they for better number of.
No, sir. Actually, what is happening? What I have found that since the department is defined and everything is defined, they wait that some more students will pass out, which is not strictly speaking is not correct.
No, that's not correct.
So UPSC, the requisition is sent by the government to the UPSC. But in your case, you are yourself advertising. That kind of situation is also not there. So apart from that, now the next question is why it is equitable? Because by denying somebody, by cancelling or re-advertising, less number of candidates can become eligible, less competition, and the equality of opportunity guaranteed by Constitution is also violated. Both ways. So you have to consider them. You have to consider them if they authorize. But simply because you are advertising 5 times, 10 times, or twice, thrice, whatever may be the reason. Or maybe the case where, like I gave you example, though there is a mandate of the direction to advertise, the High Court has not been able to advertise. Any court in India. The second, the usual is that somebody eligible to apply for the Odisha Judicial Service has to be made, he must apply. Who was not eligible to apply in the last advertisement, he cannot.
Yes.
Obviously. That is not the, that will be extreme case. Like I gave you the example of police recruitment, constable or some recruitments. They are saying that it should be extended ad infinitum. Even the state government considered for 3 years. So you permit them. You can open that instruction that they only say, because I think, but then why it was kept pending for since 2017? 21. That's a 21.
21.
Counter has been filed.
Counter has been.
So what is your answer to this? That how you have dealt with this anything on this particular aspect?
In fact,
about this matters, nothing has been spelled out in the counter as to why this was prescribed. When earlier I have given a number of advertisements of different universities, my lords, where entry age has not been prescribed. Even OPSC, my lords, have given for the post of lecturers or senior lecturers, they have not made entry age as required others.
Mr. Rathod, it is like this. I will not go into that issue whether they can prescribe or not. But if somebody is eligible in the first advertisement, then even I am not touching you whether you can prescribe. In fact, you can do a statement like that you have authority to prescribe. Well, I am not touching that. But if somebody is eligible in the first advertisement, how he or she can be deprived of the second, third, fourth, fifth?
Yes.
I am not going to enter into that test. I will not test on that, unveil that whether authority has the authority to prescribe as and when they like. That is Mr. Author's argument. There is some arbitrariness
Yes.
in prescribing the minimum age as far as. But if somebody is eligible for the first advertisement and it has not culminated into any further selection and it is aborted, let us use the word aborted. Then what would happen for the second, third, fourth, fifth?
Whether he or she will be eligible or not.
And it has to be. There is no, there can't be any two opinions. You ask me, Lawyer Junior, there are several decisions on this. There are direct decisions on this. Apart from Malik, way back 1970 was the Yes, Mr. Patnaik, just respond to only that aspect.
I'll
When do you want?
anytime.
I will not go into the aspect whether you have power and authority because I will leave it open.
Anytime convenient to your lordship. At least 1 week's time.
Okay. Mr. Jayanta Ratha, senior advocate, along with Mr. Durgesh Narayan Ratha for the. You take your seat, I'll dictate the order. Please kindly take your seat. The Jayanta Ratha, senior advocate, along with Mr. Durgesh Narayan Ratha for the petitioner. Mr. Tarananda Patnaik for the opposite party. One, two, and three. OP number 4 was issued notice.
My lord? Yes, my lords.
OP number 4, none.
Everybody had notice.
Okay.
But he is represented by one of our lawyer brothers.
Okay. None for OP number 4. The lawyer senior advocate appearing for the petitioner was heard at length. He refers to the advertisement dated 7/8/2019 issued by the opposite party university. This is for chief librarian.
My lord.
Chief librarian.
She was again. First advertisement of 7th of August 2019. It was advertisement issued 3 days back. After it was taken back. Then the second advertisement, I was a candidate by that was on 16th October.
No,
I mean,
first was along with other certain
chief librarian.
other posts.
Post का कौन होता है? Librarian, chief librarian. Chief librarian. कौन लिखे?
In my case in the counter is that first was along with others, but the other advertisements were.
Let us have it that on 16th only for chief librarian.
Okay. The petitioner was intending applicant for the post of chief librarian. In the nature of post regular, number of post 1, category 01. You take your seat. I'll require your assistance. I'll ask you. I'll take some time. Category 01 in the unreserved. The last date of filing of the online application was 12.09.2019. The Lord Senior Advocate refers to the paragraph Roman 3 that prescribes that prescribes qualification and experience. The page 25 will be the said paragraph is reproduced here. This advertisement did not prescribe any age.
No age.
It is the senior advocate refers to the paragraph English 3.
Only age of superannuation was mentioned.
That provides age of superannuation to 60 years. कौन जो रोमान से लिखने नहीं तो लिखने 1 dot English 1 dot capital Roman 3 into that. The senior counsel highlights the fact that the state advertisement did not prescribe any minimum age for applying to the post. It then refers to the advertisement dated 16/10/2019 which also by which applications were invited from eligible candidates for recruitment to the post of chief librarian. The last date being 30.11.2019. Referring to the said advertisement dated 30/11/2000, said advertisement dated 16/10/2019. It is submitted by the learned senior advocate that the advertisement also did not prescribe the minimum age of application. The age of superannuation was only prescribed to be 60 years. As was prescribed in the earlier advertisement. Thereafter, third advertisement was issued dated 3/12/2021. The last date being 21/12/2021 by 23:55 p.m. The application form for online application was available from 8/12/21. 10 a.m. Page 29 in the key referring to the said advertisement dated 3/12/2021, it is highlighted by the learned senior advocate that the said notification issuing the advertisement also indicated that the advertisement dated 16/10/2019, page 29 up to apply afresh quotations. The learned counsel, the senior advocate, referring to paragraph 3 of the English 3 dot of the advertisement dated 3/12/2021, submits that for the first time qualification of age, prescription on age, prescription on minimum age, not minimum, maximum age, prescription on maximum age was provided, that is below 45 years as a last date of application. Everything else, particularly qualification and experience, remaining unchanged. To substantiate his submission that such a condition is discriminatory per se and irrational, is discriminatory and irrational per se कर दिया अंतिम कहो. He draws attention to the qualification prescribed, that is qualification and experience, that is 10 years experience in librarian. आज जवाब अपन में भूलभाल लेक्चर थी 10 year experience in librarian कौन 10 year experience in librarian into bracket sick in पर लिखिए sick आज in any college, university, etc. To submit that, to have the experience as well as to have the minimum age would be difficult for a candidate to achieve. It is submitted that in any event, pursuant to the first advertisement, the petitioner the petitioner in the present writ application in particular, and many other candidates, oblique intending candidates who were eligible, have been debarred without any reasonable nexus with the objective to be achieved by prescribing a minimum age. In the third subsequent advertisement, cancelling the earlier two advertisements. Para. The learned counsel appearing for the university has adjournment to obtain instruction. How the person who was eligible, even if the prescribed age is taken to be maximum 45 years, as per the advertisement dated 7/8/2019, can be disqualified in a subsequent advertisement. Disqualified, no, can become ineligible. Can be declared to be ineligible. Declared, not treated, can be treated to be ineligible. As the advertisement dated 7/8/2019, 16/10/2019 have merged with the advertisement dated 3/12/2021. There being no selection pursuant to the earlier two advertisements. It is submitted by the learned counsel for the learned senior advocate for the petitioner that the said aspect has not been answered in the counter affidavit. The learned counsel appearing for the university will address regarding
Not answered wouldn't be correct.
See question.
Madams.
See question. As directed, the learned counsel for the university has adjournment to address on the same issue. This aspect, there are case laws on this point that if counter report lecture that process was culminated in any selection. But I think that cannot be, because the second, third advertisement makes it itself clear. The earlier has to apply afresh.
That has been made clear.
Then if you debar somebody, then how he can apply afresh? That is another technical question also. You are asking him to apply, say somebody, but by the time of the prescription is that he cannot apply.
That query of...
So you can condemn also, no difficulty. Those who have not applied, that's a different thing. Those who have not applied, you can, yes. Correct. I cannot now turn around and say that I could have applied.
Definitely.
Correct. Yes. List in the week commencing
16th of March.
I'm not last week. We are in the last week of February.
Yeah, exactly. I'm only indebted to you.
The week commencing 16 March.
Yes.
The matter to retain its position in the list.
This is
26 minutes. Mr. Das, my
paucity of time. Rest of the matters they cannot be.
Because he was
to
only
start
flex.
Rest of the matters and any suggestions for any date kindly make and he will make it. Page 5.
26 also.
26 any date has he suggested any date?
No date he has suggested.
Okay. About 26 ଟା date ଯାହା କରିଦେବେ ସେ କରିଦେବେ.
ଆମର item 35 କହୁଥିଲି ଯେ date of application ହବା କଥା
right.
ଉପରେ ଟିକେ ଆସନ୍ତା
25 matter ଆଣି ହବନି. These things are unable to, we cannot, aguru joda hei parutila computer re houni. Wait kote karantu. 35. सर्विस मैटर टिके समय लगे सर्विस मैटर आसिला मिस्टर पटनायक करो
Item 26.
we commencing 16 kale 16. So please take dates wherever the parties agree. For any date you can suggest, no difficult.
Item 36 re Mr. Das was there on the last occasion. He asked me to give the notes of submission and citation he is relying on, so that I can take the instruction. There is a direction also to take instruction by me.
The copy debe
again. So they in
copy and
intimate. Next time the same thing.
Sir.
Yes.
I request. Item 32.
32.
The TRPC application.
Date चाहूचंदी.
No, short date कौन सी they are
short date sir आपको notice तो जहाँ भी distribute करेगा पड़ेगा. सही priority रहेगा.
No, what is happening?
Wish admission then order
The
stand.
opposite party took time to file objection, my lord.
Today sir one matter after 9 years it has been said TRPC stay here.
No, ଆମ stay ଅସୁବିଧା ହଉଛି ଆମଟା stay ନାହିଁ.
तो देखिए let us not hear on merits. To be fair to the other side also.
No, I am not only.
Unless you take a date. The date दे दियो sir.
Short date.
Short date से distribute ହେଇକି ହବ 16 30 କେତେଟା 6 4 କୁ ବି ଯାଇଛି.
Lordship.
4 my lord.
Last date रे note of submission ପାଇଁ
note of submission ଆପଣ argue କରନ୍ତୁ. after the matter reaches
दिया होगी तो
अभी तो पढ़ी नहीं ना. I cannot observe either way. that is ସେମାନେ ଦେଲେନି ବୋଲି. So
short date each stage ରେ ସେ maintenance ଦଉଥିଲେ.
ସେଟା ତ strategy. ଥରେ maintenance award ହେଇଗଲେ ଯେତେ adjournment ନେଇ ପାରିବେ.
Subject ସେ challenge.
That is law. What can be done?
Item 37.
Yes. Take a date, sir. Take a date.
Item I have appeared yesterday only. We have not received notice.
Sir, ଆପଣ ଯଦି suggest କରୁଛନ୍ତି, both sides are there. You suggest a date, he will give you. No difficult.
Copy will be served. That is the only thing.
ସେଟା ଏବେ କରିହବ. Paucity of time. Orders. Okay. So,
Item 40.
Yes.
Short date may be given because it is a hearing matter, but it can be disposed of. It is covered by a judgment of the Supreme Court. Item 40.
Other side को कौन तू?
ମୁଁ କହିଯାଏ short date.
Yes. Thank you.
Sir, 26 टा कोड में बोला है 26 ଟା 23 ଦିନ 30 ଦିନ 30 ଦିନ
40 ଟା କେବେ କହିଦେବେ ଦେଲେ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ କହିଲେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେବା ପାଇଁ ମୁଁ କହିଲି ତମେ ଯୋଉ ଦେଇଛ ମତେ